1 and 2, on behalf of petitioner, I have filed additional affidavit on 25th, Lordship. Lordship, it is not in record. Kindly allow me to bring it record.
May I please, Your Lordship? My lord, I have prayer in item 19, my lord. On last occasion, my lord, I was directed to, my lord, get the instruction whether the petitioner is paying the interim maintenance of rupees 5,000 to the respondent wife or not, my lord. Lordship, I am praying before Lordship just 2 weeks' time to get the instruction. Since
You are the legal aid counsel.
I'll inform him. I'll inform him.
You
I have not informed.
are the petitioner.
I'm the petitioner.
Have you informed him?
I'll inform the other counsel.
Please don't make a mention without informing the other side.
My lord, I
The
understand.
protocols for mentioning are loud and clear.
My lord.
Please don't cross it. Yes. Wait for your turn.
Maybe I beg to mention item number 21 and 22, my lord. I have item number 21 and 22, my lord.
Yes, what do you want?
I am paying for adjournment, my lord. I have taken consent from other side, my lord.
You are for the petitioner?
Petitioner, my lord. I am on behalf of Mr. P.K. Roy Sodhi, my lord.
What is your name?
A.K. Azad.
Mr. A.K. Ajat, learned counsel, appearing on behalf of Mr. P.K. Roy Chaudhary, learned counsel, for the petitioner with consent from the other side, seeks accommodation in the matter. Prayer is allowed or after Bihu date. Relist on such and such date.
Obliged.
Lordship, Lordship, with the consent of the other side, I beg to mention item number 15, Lordship.
Item number?
15.
Yes, what do you want?
Lordship, pass over for the day, Lordship.
15 is along with 14. Who is appearing in 14?
14 is appearing you, Chaudhary, Lordship.
Have you informed?
Yes, Lordship, I have informed.
And what about the other side?
Other side also I have informed, Lordship.
You have informed everyone?
Lordship.
For the state lordship, whether she has informed respondent of the tree election.
Huh?
Respondent.
14. Mr. Chaudhary, you're there?
Yes, I am appearing as a legal.
You are appearing for?
In item number 14, Lordship.
Yes.
What
Any
happened?
objection?
No.
MS
A point.
A. Payang, learned counsel, appearing learned counsel for the appellant in criminal appeal 412 of 2017, seeks accommodation seeks accommodation with consent from the learned counsels appearing in criminal appeal J106/2007, as well as the respondents. Prayer is allowed. Relist when?
After a week, Lordship.
Such and such date.
Obliged.
23rd.
23rd April.
23.
May it please, Your Lordship? I beg to mention item number 16.
Item number?
16, Your Lordship.
16?
Yes.
Yes.
My senior is unavailable due to some personal reasons. The matter may be adjourned for the day, Your Lordship.
It's a quashing matter. You can try.
No.
Why? Why no?
I'm just new.
So,
Your Lordship.
these are opportunities. All right. You have the brief.
No, Your Lordship.
Why you have not brought the brief?
My senior had to go urgently, Your Lordship.
All right. You do one thing. Photo copy to Diba. You have a look at the brief. When the matter is called, if you are confident, I will hear you. If you still want the time, I will grant you. But this court is giving you an opportunity. Grab it. Yes.
Thank you.
May I please, Your Lordship? Lordship, in item number 14 and 15, can it be on some other day, Lordship? There is some personal difficulty on 20.
Yes. When do you want it?
Any day thereafter, Lordship. 30. Obliged, Your Lordship.
Lordship, I beg to mention item number 17. I'd like to inform the court that we have misplaced the file.
Misplaced file.
Misplaced the file. So if your Lordship would permit.
When did you realize that the file has been misplaced?
Lordship, last evening.
Mr.
P.D. Chaudhary, appearing on behalf of Z.
Mr. P.D. Chaudhary, learned counsel, appearing on behalf of
Senior Counsel Z. Kamar.
Mr. Z. Kamar, learned senior counsel, submits that the brief has been misplaced and accordingly seeks accommodation to reconstruct the brief. Prayer is not opposed. Relist after 4 weeks on a date to be fixed by the registry.
Obliged, my lord. Lordship, may I get access to the court copy?
You reconstruct.
Obliged.
You cannot take out the file from here. Ms. Bora, you have a copy?
For
Yes,
admission,
call the list.
item number 1 and 2.
Kindly pass over a matter for time being, Lordship.
Passover today I have difficulties, Lordship. Just now,
Time being.
time being, Lordship, I have difficulty. Two person matter is another code, Lordship. Then, any otherwise, Lordship, just now I have come to know that they have filed additional affidavit, Lordship, after concluding, almost hearing was concluded. Without the leave of the court, Lordship, how they can file
That
additional.
anyway, we will look into
Additional-
later, but you
Yes,
make
pass.
an argument.
Lordship.
If you want another date, in the meantime, you
Lord,
have a look
today,
at it.
Lordship, time being, I have difficulties, Lordship. Today, time
All
being.
right, when do you want it, Mr. Gogoi?
Any day, Lordship. Any day.
Tuesday, Lordship.
MS N
R.
Mahanta, Leonard,
R. R. Kakoti.
MS R Kakati, RR Kakati,
RR Kakati.
Learned Council, Learned Council for the petitioner submits that Mr. K.N. Chaudhary is on legs in another court and seeks accommodation in the matter. Mr. R. Gogoi, K. Gogoi, Learned additional, you are appearing as Learned DYSJ.
Central Government Council.
Learned Central Government Council submits that the matter may be submits that since accommodation for the time being is sought, however, in view of his occupancy, in view of his schedule today, it shall be convenient if the matter can be taken on another date. Prayer is allowed. Relist on when do you all want it?
Next Thursday.
Thursday.
Possible.
Kiman matters as a sile word, dear.
7th of April.
On 7th April, interim, if any, shall continue till the next date of listing. 1 and 2.
Lordship. Apologies.
Item number 3.
Yes, Mr. Kothari.
May please, Your Lordship. Lordship, this is a criminal petition under section 482. But before I begin, Lordship, there is one difficulty. I went through the records. The LCR has not been called for. Even on perusal of the previous orders, I realized that the LCR has not been
PCR was not called.
not called. Although there is a stay, Lordship, as per order dated 17/12/2018.
Is TCI required? This is the
Otherwise,
question.
Lordship, since we are challenging the act of taking cognizance without obtaining necessary sanction, up to your Lordship. Otherwise,
So whether the records will show.
Lordship, the quashing of any complaint is to based on the basis of the
That's
complaint.
right, but not only on the basis of the complaint, also on the basis of the
But
materials
there would
collected,
not- Lordship.
collected by the prosecution, isn't it? Now,
No, it is a complaint case, Lordship.
correct, even in complaint case, there
The
must
complaint
be,
has been annexed.
complaint is annexed. What about the documents exhibited? What about
No,
the,
that very at the threshold case has been state, Lordship.
where is the order?
17/12/2018.
Order, where is the order?
Lordship, order dated 17/12/2018.
Where do I get it? Which page?
Lordship, LCR would be necessary. LCR would be necessary, Lordship.
That's why.
Yes.
So I'll admit it and call for the TCI. There's no
Yes,
point of keeping this matter in the admission column
Lordship.
since there is already a stay.
Lordship,
Heard Mr.
why could I?
Y. Kathari, Leonard Counsel for the petitioner. Also heard Mr. P.P. Datta, Leonard Counsel appearing for the respondent number 2 and MS.S.H. Bora, Leonard APP for the state respondent. It appears that the petitioner has made out an arguable case Stop. Admit no formal notice as parties are represented by the respective counsels. Let the trial court, let the case records be called for from
GR, additional
Lordship.
CGM, Lordship.
from the
Additional
Where
CGM
do I get
Kamrup
the
Metro.
reference?
Lordship, that criminal revision petition number 22 from the session judge, Lordship.
1 second. Mr. Datta, where do I get the reference?
Lordship, you find it
From the
page
additional
24.
Yes, I got it. From the court of the additional session judge FTC number 4 Kamrup Metro Guwahati. In relation to criminal revision number
That's it.
28 of 16,
Yes, as
Lordship.
well as the trial proceeding
as well as
before the additional CGM.
the trial court records from the court of
Additional CJM Kamrup Metro.
additional CJM Kamrup Metro
In respect of GR number
in respect of GR case number 6707 of 2014.
2014.
Okay.
Yes.
I said call, isn't it? All right, that's sufficient. We need to say it through the registry. Registry is directed, you say it. Okay. Let registry call. Okay, that and relist after 3 weeks. After 3
Or a date
weeks.
may be fixed or else-
On a date to be fixed by the registry. I'm not fixing it for hearing right
no.
away because let's see what happens on the next date.
Lordship.
Interim is there
Yes, interim is there.
to be continued or it is for until further orders?
No, to be continued. It has been
Interim, if any,
continued.
shall continue till the next date of listing.
Lordship. Deeply.
Supplementary list, item number 25.
Yes, Mr. Mohanto, what is this
482
petition?
application matters.
Huh?
482 petition
Yes,
challenging the FIR, the corresponding charge sheet
yes.
and the impugn order of the JMFC swing process, my lords.
What is
On
the
the first date,
charges?
my lords,
What is the charges involved?
409, my lords.
409.
Criminal breach of trust. On
Uh,
the first day, my lords,
So FIR, cognizance and process.
process, my lords.
okay.
FIR, charge sheet and process. my
Oh,
lords.
charge sheet is charge sheet submitted by the.
Yes.
All right.
Now, on the first day, my lords, an interim order was passed
Hmm,
wherein the honorable single judge
hmm.
had formulated a question, my lords.
Question.
While granting interim order. A law
Yes.
point was formulated, my
Then
lords.
619, are you referring to the order
Yes.
10/6/19?
10/6/19.
Yes.
This second last paragraph from the bottom.
On the next date, Learned Counsel for the parties to address this court on the law
Law
point
point.
formulated by this court. What is the scope of inquiry by the learned trial court at the stage of framing of charge?
Because
There
my,
are several decisions.
there are several decisions, my lords. So perhaps, my lords, I have to address my lords on this question as
You
well.
have Krishna Iyer's decision.
Yes, my lord.
You have it. 78.
78.
You
My
have
lords,
it.
that law is somewhat settled like my.
Yes,
lords have-
because I think a test has been laid down
Yes,
in that case
yes,
by
yes.
Justice
Only
Krishna
when
Iyer.
perhaps a person is discharged, there has to be reasons which has to be recorded. Otherwise, there has to be a prima facie case.
And framing charge, I think that there is an order of in that the mobile company, that famous case.
Vodafone.
No. Anyway, yes,
I'll find out. My lords, if I may pray, my lords, I need
we need more time.
place some judgments also. It's first,
Why? Prepared, Mr. Mohan.
I'm prepared, my lord.
This order was passed in 2019.
19, my lords. I've been recently engaged, my lords. I was not there before.
You have been recently engaged.
Recently, my lords. It was handled by my senior, my lord. It can come up for hearing, my lords. We'll take it from the
Not
matter
hearing because
Hmm.
this matter has to be admitted.
admitted. In fact, the respondent number 1, who was the informant, I've been told he has expired, my lords.
Where is the FIR?
FIR, my lords, would find at page 25. From the FIR 25, my lords. I think much is discernible from the FIR itself. my lord.
Charge sheet?
Charge sheet, my lord, page number 29, starts from 29, the type copy, my lord.
What is wrong? Charges, it appears investigation was done. There is allegation of misappropriation.
Right, my lords. And page 36 is the
Now,
order.
whether the allegation is correct and not correct cannot be gone at the stage of framing of
Exactly,
charge.
exactly. My sole point is, my lords, whether a charge under 409 can be attributed to my client who was the branch manager, my lord. My client, my lord, if my lord takes up the order under challenge, my lord,
I'll admit it and fix
Let
it
the matter
for
be fixed for admission.
hearing.
hearing is.
And in the meantime, we'll address the court on the issue formulated. I'll keep that open
My lord.
Yes.
because
Our contention is, my lord,
or let
entrustment is
it
not.
be in the admission. I will simply adjourn it, giving you time to address the court on the question
My
formulated.
lord.
I think that would be appropriate. Mr. M. Mohanton, Learned Counsel for the petitioner, submits that he has been recently engaged in the matter and he seeks further time to address this court on the questions formulated by this court by order dated 10/6/2019. Stop. It appears that prayer is not opposed. Relist after Bihu
My lord, after.
on such and such date.
Very grateful. P. Mohanto. P. Mohanto.
P. Mohanto. What did I say?
M. Mohanto.
Why did I say them? I don't know.
Very grateful. Oh, Rakhi.
Item number 5.
Yes, Mr. Deka. This is that medical bill,
Yes.
but I have forgotten, huh? Let me be very honest to you both. You have to refresh my memory and get me back to the track. Only a little bit of, just narrate the facts and.
Lordship recollects, is a case
And
where
why
the-
is the matter posted today? I believe you had finished your argument.
I had finished my argument, my lord. It was fixed on 2 days back. It was not listed.
Okay.
And somehow your lordship was sitting in the division bench.
Okay.
Then again it has come.
And have you, you have also finished your part?
No, on law points, I will have to submit.
If I may take your lordships to the award,
Hmm.
I think that will clear everything.
Yes, yes.
Briefly stated, my lord, the respondents number 2's wife, she fell sick. She was brought to the hospital, whatever the guardian has to maintain under the act and the rules. She was detected with cancer. Without our consent, they took her to Bombay. And then they submitted the bills, which we have refused. But there is a concession, so far as our management is concerned, that till the treatment in the Jorhat Medical College or Guwahati Medical College, we are ready to reimburse.
You are ready to reimburse.
We are ready to reimburse, but not the entire amount. The question, the
That
point
was a
of-
concession,
that was a concession given.
but under the,
Under the law, I am not required to pay anything.
correct, there is nothing in the law which mandates the management to pay the medical bill, right?
The law mandates the, as per our size of our garden, to maintain a something called the garden
Unit,
hospital.
garden unit, hospital unit.
Garden hospital. And that, it is nobody's case that it was not there.
I think it was, the labor court has found that that hospital, that
That-
unit,
That
something.
cancer treatment ought to have been there.
How can that be?
That was the finding.
That is
Page 40.
absolutely an unreasonable.
I'm only on that.
That is unreasonable. Where is that order?
That page 40, that finding is there.
40.
40, the middle portion.
Mr. Deka, but you will have to
Yes,
also
yes.
say a little bit of the facts because if I can, I'll dictate the judgment right away. So I'll need to know the facts a little. Page 40.
Page 40.
39 is that medical facilities. This is from section.
Yes, this is
10.
from section 10 of the act.
Plantation Labor Act Condibody, our industrial dispute.
I have 2 copies.
Yes, let's read section 10.
In every plantation.
One second. We can read it from the book.
I see. Section 10.
Yes, it's already flagged. Yes,
In every plantation, there shall be provided and maintained so as to be readily available such medical facilities for the workers and their families as may be prescribed by the state government. If in any plantation medical facilities are not provided and maintained as required under subsection 1, the chief inspector may cause to be provided and maintained therein such medical facilities and recover the cost thereof from the defaulting employer. So I am required to maintain certain facilities. If I do not, the chief inspector
Has
will
it
recover.
come out in the evidence? What are these medical facilities that you are required to maintain?
It is there in the rules.
Yes, please.
Rule 35 of the rules. If your lordship is
Yes,
having the
please.
same book,
Yes,
then it is
yes,
a
I've
place-
got it.
I think it is flag marked.
Yes, it's already flagged. Now, that is why I use my book because it's all flagged.
So it is rule 35.
Types of hospitals.
Yes.
Yes,
Rules prescribed under section 10.
yes.
There shall be two types of hospitals in plantations, namely garden hospitals and group hospitals.
Yeah.
Garden hospitals will deal with outpatients, inpatients, not requiring any elaborate diagnosis and treatment, infections cases, midwifery, simple prenatal and postnatal care of infants and children, and periodical inspection of workers.
Yes.
Group hospitals shall be capable of dealing efficiently with all types of cases normally encountered, but will not be used for routine treatment. Admission to group hospital shall be only on the recommendation of the garden hospital doctor.
Yes.
Then 36(2) will be relevant. Every employer of plantations ordinary employing less than 500 workers may
So all types of cases normally encountered.
Normally encountered.
Normally
Normally
encountered,
encountered.
it might mean someone having stomach issues.
stomach ache.
Correct, where you
infections,
might need
maybe a snake bite also.
correct, where you might need
Yes.
hospitalization.
Maybe
because of-
injury, someone has fallen down.
Because it says normally encountered.
Normally.
Yes.
So subsection 2 says of 36 that every employer of plantations ordinarily employing less than 500 workers may, however, provide a garden hospital in his plantations according to the standard laid down in these rules, or have a liaison on the beds of a neighboring hospital, a neighboring garden or other hospital to the scale of 15 beds per 1,000 workers.
Yes.
So I have pleaded in my writ petition that I have a worker strength of 160, so I'm required to maintain a garden hospital.
Right.
Now again 42 may be relevant.
40,
2.
42.
What if I failed?
Yes.
Failure to
Just
provide and
one
maintain.
second. I think the standard of medical facility starts from 40. Let us just see that and then go to 42.
Ultimately, my lord,
Rule
everything
40.
is prescribed in the that
Rules.
schedule. There is a notification,
Yeah,
what we are
we'll go-
required to
we'll go
provide.
that, just
40, we may read 40.
yes, please.
Outpatients treatment. Lordship will first take 38 then.
All right. Equipments and
No,
stuff.
let us start from 37.
30.
37 is group hospitals.
1 second. Yes.
If we turn to subsection 6 of 37,
Yes.
what a group hospital is required to have.
Yes.
OT block, X-ray block, physical therapy block, dental, labor room. These are
Demo is not here.
not here. This is a group hospital. Big garden will have a group hospital.
Group hospital is for the normal encountered.
Yes. Then 38 says equipment and drugs. Every dispensary, garden hospital and group hospital shall maintain such equipment and drugs as may be specified by the state government. This is also specified. Then 40
Okay.
says standard of medical facilities. Outpatients treatment, it shall include detention for observation and treatment, preventive treatment such as vaccination and inoculations, free provision of all drugs, including those needed for injections and dressings and applications that may be considered necessary, antenatal, natal, and postnatal advice, provision of certificates free of cost in respect of maternity and sickness
Okay.
benefit claims under section 32 of the Act.
All right. The hospital treatment shall include in consultation.
Then what is inpatient? Because Lordship sees that in garden hospitals,
Yeah.
I'm not required to have. No, I'm required to have inpatient, but not requiring any elaborate diagnosis.
Correct. See, as I said, stomach issue.
Then we can go over to 42. What
Yes.
happens if I fail to?
Yes, if anyone does not provide.
If any employer does not provide and maintain medical facilities as required in these rules to the satisfaction of the chief inspector, the latter will cause to be provided and maintained these facilities in the nearest garden hospital or dispensary or in a district board or other similar hospital, or if he considers necessary, authorized either by general or special order medical treatment of any qualified medical practitioner and oblique or in any hospital that may be found convenient. The defaulting employer shall be liable to pay the cost of such medical facilities, not the treatment. What you will kindly mark, it's not the treatment, it's the cost of the medical facilities, including charges, if any, in respect of a medical officer's visit to the plantation for the purpose of attendance of any sick worker or workers, the maintenance of sick worker in hospital dispensary for each day's maintenance, and
So this says,
this is,
but this is only.
if I fail.
Only, see, fail cannot mean that you have not not given the, you have failed to treat him, to give him the cancer treatment, because
No,
that.
I am
the
going a
first-
step further.
Correct. The first question that has to be decided by this court is whether the treatment of cancer falls under the, under any of the services, facilities which you are mandated under the Plantation Act and rules, or not. Correct?
Correct.
Now, if the answer to this question is no, then the question of failure also will not come.
I am
Isn't
going
it?
a step further.
Correct.
That even if I have failed, suppose
Yes.
I am required to maintain certain facilities,
Hmm,
I have failed,
hmm.
then the chief inspector will enforce. Now it is nobody's case that I have failed.
That's right. That is
That
your
I am not
alternative.
maintaining the
Correct.
garden,
That
nobody's
is what
case.
was also, I would have asked you whether there was any report called from
Nothing.
the, so
Nothing.
there is no report
no
or
report.
evidence showing that you have failed to provide the
Exactly.
services. It
Exactly.
has been presumed that cancer treatment ought to have been given by you, because you have not given, now you have to
Absolutely,
pay.
absolutely. And what is required to be provided, there is a notification dated 20th of June 2005, that is in my book at page 131. If your lordship is having this book.
1 second. And this is also given that if any group of plantation required under these rules to provide the facilities of a group hospital fail to do so, the state government may recover the cost thereof by levies based on the hectare age under T and all that. So a
Everything.
detailed manner is also given.
It's a detailed manner.
These things were not done. They have also not filed any complaint before the chief inspector, isn't it? Yes. Where do you want me to go?
If the lordship is having this book. Yes, page 141 in all probability.
Page?
141.
Clause 59.
Clause, no, but it's a
Yes, yes, it's
notification.
already,
It is a
flagged.
notification.
it's already flagged. Yes.
142. What are the list of equipments to be maintained in tea garden hospitals and dispensaries?
Yes.
But even otherwise, my lord, by no stretch of imagination can it be expected that a hospital, a garden hospital will provide cancer treatment. My lord.
Yes,
My lord,
that
till
you
the
are
other day, even the GMC did not have.
correct. That I agree with you, Mr. Decker.
That is what is the crux of the issue.
That I agree. But now, however, in order to see whether there is an error, because ultimately you have come before the tertiary jurisdiction, right?
Yes. So
That is
so-
why I want to see if there is any
Exactly. So that-
mandate, because
that
suppose
error-
there is any requirement in law that you have to provide this facility and you have not done, then of course you will have to
Yes.
face the
that
consequence.
I'll have to face the consequences.
Yes.
Now, 39, the Learned Labour Court recites the section 10. Then this finding I'm agreeing, my lord. Thus, from the above provision, it is clear that not only workers but their families are also entitled. I'm not disputing this. Therefore, I find
You are
this.
going back to the judgment.
Yes,
All right, all right. So from here, you just wanted to show that what-
cannot be, my lord. Cancer treatment is nowhere
because
prescribed under the rules.
none of the required equipments
Yes.
for treating
I'm required to
cancer.
provide for basic care of obstetric and gynecology, ENT and dental certain sets.
Yes, okay. Yes, para 10. Thus, from the above provision,
This I'm in agreement with the Learned Labour
therefore,
Court.
I find force in the company of the workman so far as the medical.
Family is
of the
concerned.
of the
Family is included. Now, we may skip the first paragraph of that page 40. Second paragraph, I have considered. I have considered the submissions of the learned counsel for the management. Though there are two types of hospitals, but the management has failed to show the treatment of cancer is available either in the garden hospital or in the group hospital.
This is a
This is the-
absolutely palpably an erroneous
Absolutely.
finding, Miss Bhattacharya, you have to
Yeah, I
deal
will- I
with
will- I
that
will-
because you have to show me from the Plantation Act and rules that the management is required to provide treatment for cancer.
No, I will, on that, I will satisfy your lordship.
Because I think we all know, we have all seen these garden hospitals, isn't it? I don't think.
Your lordship knows the condition of garden hospital. It
Yes.
is very pitiable condition, my lord.
But you see, that is another thing. Now, that is not an issue before this court now.
Yes.
The issue, suppose it was a case where the person was having jaundice and treatment was not given, then of course.
My lord, here, my
But
lord, what
or
happens?
fever,
Yes.
or as he said, snake bite. Because then
It is a possibility.
it is a possibility.
That is why dispensary is there, my lord.
Correct, but the dispensary,
For my lord,
the
immediate
equipment,
treatment.
you see, you cannot, by no stretch of imagination, you can, reasonably, you can say that a garden is required to,
No, that I
under
understand.
these rules.
That I understand.
Provided the state government provides
Yes.
that, yes, even chemotherapy, everything is required, then it would have been a different,
Yes,
isn't it?
yes. But
don't
my lord,
think-
for that,
Because
my lord,
which is this garden?
Kakodonga tea estate.
Kakodonga
In
tea
fact,
estate.
companies like Warren, Goodrich, I don't think even
No,
they
they
have
will not also not.
hospitals providing cancer treatment.
No, my lord, their provision is there, my lord. I will satisfy your
You
lordship.
show
my
me
lord.
the provision, because
No,
if
no,
you are
yes.
successful in showing
Yes,
the
I will
provision,
so
then
your-
certainly this court is going to
As because my
direct
lord,
the management to
yes, as
reimburse.
because my lord, there is lack of facility, a person cannot be allowed to die, my lord.
You see,
that is the
lack
concept
of
held by the-
facilities is
yes.
a different issue.
Yes.
Now, the finding of the labor court is that though there are two types of hospitals, but the management has failed to show that treatment for cancer is
That is-
available either in the garden hospital or in the group hospital.
Yes.
Now, we are only concerned with this.
Whether cancer.
Correct. So now, in order to hold that this view is correct,
Yes.
you must show me that under the provisions, it is mandatory for a garden to provide treatment for cancer. Now, this you can only show from these rules.
Yes, but if not, my lord, it is, they can take the patient outside, my lord.
Where
because,
is it given?
On that, I will satisfy. your
Where
lordship,
is
my
it
lord.
given here?
Let my learned friend finish, my lord. I will-
First of all, that provision, that service has to be available.
Yes.
Only if
not,
that
my
service is
lord.
available and it cannot be done there, then they can take it out. But it has to be relatable to that
No,
service.
I
because
will
if
satisfy.
we
your
go by
lordship.
these
Yes.
rules, it says failure.
Yes,
It says failure.
Yes.
Anyway,
I will.
I'm
satisfy
just
your-
indicating my mind
Yes,
to
my
you.
lord. I will
Yes.
satisfy your.
Just
lordship.
one more thing. The labor court as well as the respondents, madam, they are relying on this act. It is not their case that it was a condition of service that whatever treatment has to, I mean, whatever the patient has suffered, the workman or the family has suffered, I am required to provide for the medical treatment. It is nobody's case that it was a condition of their service. Either it was a agreed condition in the appointment letter or it is provided in the standing orders. It is nobody's case, my lord. A perusal of the award shows that even the learned labor court is relying on the act because the finding is rendered on the basis of section 10, not on the basis of an agreement or an appointment letter that it is a condition of service.
Okay.
Neither is 9A violated. It is alleged that 9A of the Industrial Disputes Act that the condition of service has been violated. The learned labor court solely relies on the act to arrive at that finding, which in my respectful submission is perverse, my lord. But I will also.
And under tertiary jurisdiction, this court cannot go into questions of law which is not argued before the,
Yes.
because what has to be seen is whether there is
Whether there is
apparent-
perversity in this.
correct, apparent patent
Apparent patent.
error.
That paragraph, middle paragraph, my lord, that in my respectful submission is that is the error apparent.
All right, due to seriousness, let's read the whole thing now.
Due to seriousness, Due to seriousness of disease, the patient went to Mumbai for treatment. When the patient was referred to outside by GMCH, it was the prerogative of the patient where to go for treatment of cancer disease. That apart, the ID Act is a social legislation intended to protect the interests of workmen employed in various industries. Non-payment of bill to the workmen is violation of principle of natural justice. Thus,
Yes.
from the above discussion, my lord, this is in a routine manner and the entire amount is directed to be reimbursed.
All right. Yes.
And only thing in my WS, my lord, para 14 of my WS, that is the
This
concession.
was a reference case.
It was a reference case.
Where is the reference? Set out,
Reference
set out
notification,
here?
it is a page
Yes.
19.
page 90. Even on humanitarian consideration,
Even on him.
whether the management of so and so was justified in refusing to pay so and so only to so and so for his wife suffering from cancer, even on continuous weather. If yes, what relief the workman is entitled? If not, well, the reference is humanitarian consideration. So it is assumed that there is nothing in the rules which mandates you to pay for cancer treatment.
It does not presume, madam.
You understand what I'm saying, Mr. Dekra?
I follow.
Because that factum,
Because the
because
rule
the
is-
reference,
rule is
and
not-
this court cannot travel beyond the reference.
No, I'm not asking
So-
your lordship.
No, what I'm saying is for you, in support of you, because here it is talking about humanitarian consideration.
Yes.
However, the labor court has answered the reference by saying that you are liable to pay. Because you are liable to maintain that's a treatment. And
It does not say so on humanitarian consideration.
he doesn't say.
Doesn't say. so.
Doesn't say. So he traveled beyond. He traveled beyond the scope of reference.
Because had he said that no, under the act, you are not
Correct.
required.
Correct.
But on a humanitarian
Because he
consideration,
said,
you are.
though there are two types of hospitals, but the management has failed to show that treatment for cancer is available in the so and so.
So the learned labor court has gone strictly in accordance with the act.
Whereas it appears that it is in the reference itself, it is presumed that
Reference ought to have been challenged by me, madam.
no, the reference appears to be in your
On that
support,
part.
because your argument ought to have been that the question of humanitarian consideration doesn't come.
Doesn't
Because
come.
then you have so many employees, every time you will have to.
I cannot, my lord.
You are a management.
I'll have to put a
You
lock and
have
key,
to
my lord.
go as per the
I have
guidelines,
to go as per the act.
and this is cancer
And
treatment.
with utmost respect, my lord, even the reference, which is a administrative order, it cannot go beyond the act, my lord. The statute will always prevail.
So, anyway, this is one view that just
Yes,
crossed my mind,
but,
because
but even then, the labor court has gone
beyond the
beyond this scope.
scope, because
And it is not the labor court's finding that no, it is on humanitarian conditions that
is
you have to
not-
pay. It
that
doesn't say
is
so.
not. You see, for humanitarian consideration, you have fairly taken a call that all right, till Guwahati, I'll pay. That is what.
I think, my lord, that
Where
part,
is that part that you?
para 14 at page 28.
Page 28.
Page 28.
28 is part of what?
My WS.
Right. Yes.
As per the prevailing norms, as we got it. As per the
Yes.
prevailing norms of the garden, the management of the garden is ready to reimburse the billed amount up to the extent of the expenditures incurred in connection with the treatment of his wife at GMCH, as the said patient was referred to GMCH by the advisory of JTS Civil Hospital, Jorhat. But due to non-taking of the prior approval from the management of the garden, the concerned workman is not entitled to reimbursement of the billed amount as claimed by him. Hence, the management prays before your honor to pass at the award in favor of the management. This I cannot go back on now. Although there is nothing on record to show as to what was the expenses up to GMCH. That will include the treatment at the JTS Civil Hospital as well as GMCH.
So that you are ready to pay.
That I'm ready to.
But anywhere this bill is available, the
No.
figure,
Not on the records. Because the records, the bills are only with of treatment in Bombay.
Any idea how much that
That we
treatment
have
cost
to,
would have been, Ms. Bhattacharya?
No, right now I do not have any.
no, we also do not have money.
No, because suppose, I'm just thinking, I'm going to hear you. But suppose this court feel that, yes, they have made that concession, so we interfere, but, this what is given is 2,10,810, correct? This is what has been paid. So we can, make it a little less. Because this 2,10,810 is up till the treatment of Bombay, right? Now, suppose we feel ki yes, a humanitarian touch is required at, in facts of particular cases, and we may reduce it. But what amount should we reduce it to? Something has to come from your side. I cannot just simply reduce it.
I will submit, madam.
All right, Mr. Deka?
Yes, because only I have the copies of the documents submitted before the labor court. There is a slip, OPD slip of the Jorhat Civil Hospital, which says 5 rupees. And the GMCH, some medicines are prescribed, but no bills. And the bills start from page, all start from Bombay Hospital.
All right,
That will be all.
yes.
May plead your lordship. My lord, before making my submission, I will take your lordship to the facts, my lord. Here, my lord, what happens, wife of the workman, my lord, he was suffering from cancer. On 2008, my lord, guardian authority advised and referred her to Jorhat Hospital, my lord. And
Sorry, advise her?
referred her to Jorhat for treatment, my lord. And after 3 days treatment, she was referred to GMC. On 23rd August 2008, my lord. And she was admitted on 10/9/98 to GMC, my lord, and he was there at GMC up to 28/11/98. And thereafter, my lord, she was referred outside Assam, my lord. That is the slip, my lord, that is in LC record, my lord, that is Exhibit A. It says, Exhibit A says, referred outside Assam, my lord. And thereafter, due to taking her to outside Assam, my lord, there is question of financial, my lord, therefore, my lord, workman take back the patient to Jorhat and she was admitted in Sondibani Hospital, my lord.
Where do we get these facts?
From my record, my lord. From record, my lord.
Page? It must be there in a written statement.
Record will be there, no?
No, in your written
Report
statement,
must have come.
your written statement is not part of this.
No, the exhibits are not annexed.
No, I'm asking about the
Yeah, LC record, it will be there, my lord.
TCR, so written statement to workman or SNE. Give it to, just see where the written statement of workman is, because these facts must be there in the written statement.
No, written statement of the workman is part of the writ petition.
Your written statement I have just seen,
Written statement is at page 23.
page 23.
Yes.
Because it has to come out from here. Yes. For the Sangha of the workmen.
It's 23, my lord, LC record.
Anyway, I just wanted to know where this is. Yes, please continue with your submissions. Yes.
And therefore, she was referred to Bombay, my lord. And patient was admitted at Bombay Hospital on 1/12/2008. And she was there up to 1/1/2009. And thereafter, my lord, after taking treatment at Bombay for the short period, my lord, 1/12/2008 to 1/1/2009, my lord. She came back to Assam, my lord, and thereafter she submitted the medical bill of about 2,10,000, my lord.
Please flag mark the evidence of the workmen.
LC
On the record.
my lord.
Yes. Because your written statement doesn't say anything that you are saying. It's a very short
Oh, yes.
written
that-
statement.
that's- yes.
Nothing that you have said is reflected in your written statement. Yes.
And in paragraph,
It's posted for deduction. Yes.
it was anyway. Paragraph 4.
Your written statement is vague.
Yes.
At the written statement in paragraph 4, my lord. That I have,
Paragraph 4.
yes,
It simply says has reported to the OPD of Guwahati Medical College on so and up to 2011-8 under registration number and so. The treatment started on so to so. And after that, she was referred to outside for so.
yes, my lord. Therefore, at Sanjivani Hospital, she was admitted. And therefore, at paragraph 6, my lord, she was taken to Bombay, my lord.
All right. Yes.
And thereafter, my lord,
Mr. Dekan, this bill must be there on record, Annexure 4.
It is this.
See if there is anything about Guwahati, Jorhat.
No, nothing.
Yes. Yes.
and exhibit 1, my lord, sorry,
Yes, please.
our exhibit 1, my lord, that is the medical bill dated 24/1/2009, submitted to the management, my lord.
Yes.
Exhibit 1.
Of 2,10,810.
Oh, yes, my lord.
Any amount for the expenses she, right?
No.
He incurred in for treatment at Guwahati or Jorhat?
No. Well, I have given this bill only, my lord.
That this bill pertains to Bombay.
Bombay, my lord.
All right, that is the
And
admitted
thereafter, my lord,
position, Mr. Deka.
Yes.
And because of her treatment at Bombay, my lord, the patient, my lord, recovered and now she is surviving, my lord. And workman before your lordship now retired long back, my lord.
Okay.
And on this, my lord, on this point, I will submit some decision, my lord.
Decisions from Protacharya will come.
No, that
but
Supreme Court decision is there.
we will come to the decision, but
Yes.
first show me the where under the act and the rules management is liable to provide treatment for cancer at
No.
their hospitals.
No, that is not there in the
That is
rules.
not it. So that is that
not.
you are conceding.
Yes,
That
my
that
lord.
is not there.
Not there.
All right.
That is not there.
All right.
And my lord, Supreme Court, if your
Yes,
lordship
now
permits
give-
me.
Now give. If that
And I have inquired with my client, my lord.
that is not
That
there.
is not
All
there,
right,
my lord.
fair enough.
Only that. And this is the copy I have submitted, my lord.
See, if the labor code would have taken a humanitarian approach, then perhaps this code would have considered, because that was the reference, because that reference was not challenged by the other side, right? The reference is, and that is why rightly the reference have said justified or not, because there is no violation of the rules, which you also admit.
Yes,
But the labor code went on a different footing. They said that no, they have not given this service and therefore they have to pay.
And in the light of Supreme Court decision, your lordship will, I will
Yes.
take your lordship to 1996 2 SCC, my lord.
Hmm? Mr.
1990.
Deka, can you please find out from your mobile at least one cases that the labor code cannot travel beyond the scope of reference? Yes.
1996 2 SCC,
Surajit
page
Singh.
336, paragraph 11. Your lordship got the paragraph.
Yes,
11 now.
yes.
It
Please
is
read.
otherwise important to bear in mind that self-preservation of one's life is a necessary concomitant of the right to life, and is in Article 21 of the Constitution of India, fundamental in nature, sacred, precious, and inviolable. The importance, validity of the duty and right to self-preservation has a basis in the right of self-defense in criminal law. Centuries ago, thinkers of this great land conceived of such right and recognized it. Attention can usually be drawn from some verses, my lord. Therefore, I will take your lordship to paragraph 12. The appellant, therefore, had the right to take steps in self-preservation. He did not have to stand in queue from medical board, demanding and assembling of which barefacedly make his meeting difficult to happen. The appellant also did not have to stand in queue in the government hospital of AIMS and could go elsewhere in an alternative hospital as per policy. When the state itself has brought escorts on a recognized list, it is futile for it to contend that appellant could be no event had gone to escorts, and his claim cannot be that basis allowed.
This is a case where AIMS has the patient was not properly treated at AIMS. Because of that, compensation was sought.
No, not that, my lord.
Huh?
Not that, my lord.
What is the facts here? Because this is not about this is not under the labor law.
This is not labor law, but
Correct, because it appears that
principle is there, my lord.
that the patient was allowed to stand in long queues, and the manner the doctors have treated her.
Yes, this is not in labor law, but
Correct. Now, this is a different thing. The jurisdiction is different. Facts do not, you see, Miss Rachaya, decisions of the apex court are contextual. It has to fit in the context of your case,
No,
so
my
that
lord,
this case can be
ratio is
applied.
that, my lord. Ratio is that for survival, my lord.
Facts has to be also kept in mind. This is not a case of labor court.
No.
What is the challenge here? Let us see the facts. What is the challenge? Please read para 3, and the decision that you have given me is not complete. It is full decision of printed at the body of 1996 to SSC 336. Para 12 leke aise, baki khini nahi. Yes, please read from para 2. Let us understand, because prima facie, I don't see this decision applicable in the facts of your case.
No, this is not under labor law, my lord. That is true.
That is different, but
Yes.
otherwise also. Kindly see para 3.
At first, my lord, I will take your
And the
lordship to
question,
true.
kindly see the question. Is the hypothetical claim of the appellant for medical reimbursement valid in the facts and circumstances of this case? Is the straight question which falls for determination in this appeal.
Yes, my lord.
So in the facts and circumstances of that case. Yes, 96 to SSC 336. Now let us see the facts, para 3.
The appellant Surjit Singh, now retired, while posted as a deputy superintendent of police, Anandpur Sahib district, Punjab, developed a heart condition on 21/12/87, and on that very day went on a short leave, extending it up to 10/1/1988 on medical ground. It remains unclarified on the record of this case as to what step the appellant took thereafter to meet his ailment. However, 6 months later, he obtained leave from his superiors on 15/6/1988 to 8/9/88 and went to England to visit his son. In the case of appellant, while in England, he fell ill due to his heart problem, and as an emergency case was admitted in Dudley Road Hospital, Birmingham. After diagnosis, he was suggested treatment at a named alternate place. Thus, to save himself, the appellant got himself admitted and operated upon in Humana Hospital, Wellington, London, for a bypass surgery. He claims to have hospitalized from so-and-so a sum of rupees 3 allegedly spent in London borne by him.
And he seems he seems to have been a public officer. He was deputy superintendent of police.
Police, my lord.
Now, of course, medical allowances you are aware of. State has its own. Sorry, Miss Manijai, this case is not applicable in your case.
Ratio of the case, my lord, because
cannot be
my lord,
read without considering the ratios are in the facts. Of the issue itself is that in the facts. Sorry. Next, let us see the next case.
Next, my lord, 2003 GLT,
Yes.
case 7.
This is also Assam medical attendance rules. So it's a government servant.
Government servant, my
No,
lord.
this one's different. Government servant is different. Next,
Next, my lord, 2015,
government employee.
yes, my lord. He is also government employee. my
Because
lord.
Miss Bhattacharya, are you understanding what I'm saying?
No, I
For
am,
government employee, the position is different.
if this is a labor matter, my lord, it is my lord, service matter, that's it.
Because it's government,
Yes.
the government is bound by their by the rules which allow which entitles the government employees for medical allowances, medical
And
bills.
that's true, my lord. But
Then-
my submission is, my lord, ratio may apply, my lord. That
How
is what,
can the ratio
that is
apply
why,
in
my
such
lord.
a case where the rules itself says
Because,
what
my
is
lord,
to be maintained?
because your lordship, your lordship will
You
see.
have not challenged the rules at any point of time. If
No.
you then you could have challenged the rules
No,
before the
in my case,
report.
my lord, for better treatment, my lord, he went to Bombay, my lord.
I'm sorry, I have my sympathy with your client, but you see, everything cannot be done on that. And in fact, the labor could have approached it with the humanitarian angle because that was the reference, but instead went on. Now, as the certiorari court, I have to only see what is the error. So it prima facie appears that an error has been committed on the face of the record.
And regarding your lordship's power, my lord,
Yes,
I will submit one decision 88 Supreme Court 2168
yes,
and 1983 4 SCC
yes.
156.
88 para 10.
Para 10.
Yes, please read.
The object and আমাৰটো এটা আৰু কিবা এটা ক'ব পাৰি নেকি বেলেগ?
Yes.
Para 10, the object of enacting the Industrial Dispute Act 1947 and making provision therein to refer disputes to tribunal for settlement is to bring about industrial peace. Whenever a reference is made by a government to an industrial tribunal, it has to be presumed ordinarily that there is a genuine industrial dispute between the parties which requires to be resolved by adjudication. In such cases, an attempt should be made by the court exercising power of judicial review to sustain as far as possible the award made by industrial tribunal instead of picking holes here and there in the award on trivial points and ultimately frustrating the entire adjudication process before the tribunal by striking down award on a hypothetical ground. Unfortunately, the order of the single, this is the ground, my lord. And another
What is the
decision.
law?
Yes,
What is the law?
it says, my lord,
Whenever a reference is made by a government to an industrial dispute, it has to be presumed ordinarily that there is a genuine industrial dispute
yes, my lord.
between the parties which requires to be resolved by adjudication.
Yes.
In all such cases, an attempt should be made by courts exercising powers of judicial review to sustain as far as possible the awards made by the industrial
Made by the
tribunal
tribunal, my
instead of picking holes here and there in the awards on trial points and ultimately frustrating the entire adjudication process before the tribunals by striking down awards on hyper-technical grounds. Now, when there is no provision for mandate for giving these treatment, how did the labor court held the management
No, my lord.
liable to give those services? I could have understood
On my
if
lord,
the
yes.
if the labor court would have said that because of these reasons, on humanitarian grounds, some money is to be given. 1 lakh is given. I could have understood.
Yes.
He's given the entire bill. He's given the entire bill amount. In fact, he has traveled, the labor court has traveled out of the reference. Can he travel out? Can the labor court travel out of the terms of the reference?
And that cannot.
Then
That cannot.
where your reference is
It must be
humanitarian.
within the. And secondly, my another in Sadhuram case, I would like to point out
Yes,
paragraph
yes.
3. that is 83 4 SCC on similar ground, my lord, regarding your
Yes, please.
paragraph 3. Yes, it says, we are afraid that the High Court misdirected itself. The jurisdiction under 226 of the Constitution is truly wide, but for the very reason it should be exercised with great circumspection. It is not for the High Court to constitute itself into an appellate court of a tribunal constituted under special legislation. And this is also, my lord, regarding your lordship power, my lord.
Yes.
So, my lord, my
That is
submission
why I
now,
have been repeatedly saying, where is the error? This court is aware of the power. That is why this court is not
your lordship,
facts.
your
Now,
lordship,
I've been from the day one in this case, I'm only asking where is the error? You show me the error.
so, my lord, now my submission will be, my lord, your lordship enjoys wide power, my lord. On humanitarian ground, my lord, your lordship may consider my case. That is my submission, my lord.
Mr. Decca,
Thank you, Governor.
how much are the management, if we, as an exception on humanitarian, we want to give something, how much your management is ready to give out of this 2
That
lakhs?
is a very difficult question.
No, see, because
I had talked to them, my lord. Of course, this lordship minute record. They are willing to pay, they are saying around 30-40,000 would have been the cost maybe at that point, the maximum. So I leave it to your lordship, my lord. Because if it comes as a concession from my side, it may be difficult for me.
no, I'm not going to record your concession here.
And that concession is already there in the written statement.
That's right. So keeping that in mind,
Now some calculation and some guesswork has to be done. Because if at that point in time, going to Bombay and undergoing the entire treatment has, I
2
mean,
lakhs.
it was 2 lakhs. So it could not have been more than 40-50,000 in
Guwahati.
Guwahati. Could not have been.
All right, let me think over once.
My lord.
I'll post it on Tuesday. Tuesday আছে নেকি কিবা? Monday to বন্ধ আছে.
Even Tuesday may be closed, my lord,
All right.
because of Eid.
Otherwise, let me keep it for tomorrow. Let me have because see, Ms. Bhattacharya, otherwise this
On humanitarian. ground,
Correct,
your lordship will
correct.
consider. And it is
only on
2000
that.
It is 2008 matter, my lord.
Only on that this
Yes.
court is considering. Otherwise, the award cannot stand. There is no difficulty.
That I
The
understand.
award cannot stand.
On humanitarian ground, my lord, your lordship will
However, I
consider
can make an exception on the special facts.
exercising your lordship power under 226.
That may be. Specifically
only-
keeping in mind that the management has already given their concession in the written
And
statement.
my further submission would be that this should not be treated as a precedent.
Obviously,
And that
that's
was-
why I'm saying only in the
Yes.
exceptional, and that clarification will be made. Anyway, this is my prima facie view right now. Let me
Should we
think
post it tomorrow?
tomorrow at
And
2.
I'll also go through the judgments regarding the scope,
Yes, and
whether it
because
can go.
in
I have got
otherwise
few-
in
I have got
tertiary
few-
jurisdiction, I think you cannot pass any direction. I would just have a look at that.
Yes,
Because
also.
it's a tertiary jurisdiction, whether
I have flag marked the evidences.
please give it at 2, all right?
Okay.
Because then you also know it because I'm keeping it because then I can dictate it.
Yes.
Oblige.
Good idea.
Hearing concluded. Relist tomorrow at 2. Parties are at liberty to cite judgments, to provide judgment to the bench clerk if need be. You give it in the morning.
Yes.
Then in the break time, I can have a look if you get something
Oblige.
on that point, humanitarian.
Item number 6.
I can get rid of it. 6. None appears. Last time also there was no. None appears for the petitioner on call. It appears that on the last occasion, I-4/3/2025, when the matter was last called, there was no representation on behalf of the petitioner. Relist Wednesday in the order column with the remark for dismissal. Please mark appearance of SH Mora, APP.
Other way also, Lordship, on married. I have not found any illegality in the same order of the appellate court as
Alright,
well as the
alright.
court. I have not-
Item 7.
You make your submission on that date. So maybe on merit also we can. Yes.
Item number 7.
Amicus is there, Ms. Sharma.
Okay, MSB Sharma is there.
V. Sharma.
Yes.
Time also in one of the matters, she was appearing as an amicus. She was not present when the matter was called. All of the records.
Item number 8.
Where are all the councils?
Yes, Lordship. Some surprising. Everyone is absent.
Mati jog Sangita ase long.
Item
Yes,
9.
Ms. Sharma,
V. Sharma,
your matter was just called.
Item 7.
What is this?
Lordship is rash and negligent driving. Conviction, trial court convicted to under section 279 IPC and 304A IPC, and which is upheld by the appellate court, Lordship.
Conviction is under?
Section 279 IPC,
Yes.
rash driving or driving on a public way up to, that is punishment is up to 6 months or fine or both, or section convicted under simple imprisonment for 3 months under section 279 IPC
Yes.
and 304A IPC, simple imprisonment for 6 months and fine of rupees 5,000 in default aside for another 2 months, Lordship. And that is upheld by the appellate court. Being aggrieved, Lordship, this revision has been filed, Lordship.
Yes, Mr. Locker, you're appearing.
I'm appearing as an amicus, Lordship. So
You want to say something?
Huh? She can submit.
Okay, no, I thought you wanted to say something. Yes.
So Lordship, as I only have the copy of the petition, and so I'm relying on the judgment, Lordship. So because I don't have all the evidence.
Evidence not given to you?
Only this judgment copy and the
Then I
petition.
mean, a direct registry to provide you all the documents. How can that be?
This conviction has been given on the.
But they,
Registry to furnish
Lord.
copies of the connected papers of this petition.
I have the judgment copies to the trial court, appellate court, and a memo of revision this petition, Lordship. That much I have. And
Ms. B. Sharma, learned amicus curiae for the petitioner submits that except the petition, no documents.
judgments are there.
Judgment is part of
Yes,
the.
Lordship, yes.
No documents of the case has been furnished by the registry. Let registry furnish copies of the connected papers of this revision petition to MSB Sharma, learned amicus curiae. Relists after 2 weeks on a date to be fixed by the registry.
Item 8. Item 8. Item 9.
Matijo.
Item 8, item is the same order.
Same?
Item is 8 is this is the revision petition receipt
Huh?
against the judgment and order passed by appellate court lordship session judge, and this is also 379
Item
279 304B.
Item 8 and
8.
item 8, you are saying is same with what? Same with 7?
No, same is not same. The facts are same, Lordship.
Facts are same with what?
The accident cases.
Huh?
It's relates to accident case, Lordship.
I'm not following you, Mr. Locker.
It relates to accidental case, Lordship.
It relates to
That's negligent driving, Lordship.
accident case. Anyway, 8, nobody has come. 9, 10,
Item 10,
yes.
You see?
Made peace, your
Yes,
lordship.
Ms. Nirola.
Lordship, this is a revision petition, lordship, against the appellate judgment which whereby the petitioners are convicted under section 392 IPC. Lordship, for undergo 3 years rigorous imprisonment and pay fine 3,300 rupees. Lordship, the order of the appellate court, it is, lordship, in page number 29, lordship. Lordship, this matter, that is page number 29, lordship.
Page?
29, the judgment of the appellate court, lordship.
Yes. Yes.
Lordship, in this matter, the contention of the informant that while they are going to attend a marriage, lordship, the petitioners came to a motorcycle that is at 9:15 p.m. lordship, near a dhaba, and then there they attack the informant, and they snatch away something, articles, money and some watches and wallet, that is. But from the evidence, lordship, but it clearly appears that the investigation was not proper. Where they have, after the incident, they went to a dhaba, where the owner of the dhaba.
But you are before a revisional court. I'm not exercising appellate jurisdiction.
Yes, lordship. Absolute lordship. Lordship, then I have to read the evidence, lordship.
You read the judgment from the
Yes, lordship.
Appellate
I'll
court
read the
judgment.
judgment, lordship.
para 2.
Page number 29, lordship. May I, lordship? Both the appellants are taken up together for disposal since the both appellants have been preferred against the common judgment and order dated 7/4/11 passed by the learned JMFC in GR case number 978 of 2008 under section 392 of the IPC. The learned magistrate, having found all 3 accused appellants guilty of committing an offence punishable under section 392 of IPC, sentenced them to undergo rigorous imprisonment for 3 years and to fine them of rupees 300 each in the default payment of the time to suffer simple imprisonment for 30 days. The case of the prosecution in view is that on 29/5/2008 around 9:15 at night, when complainant Sri Deepak Bhawal along with his friend Sri Pankaj Paul was proceeding towards Huang on highway near Boga Dhaba, 3 youths came riding on another motorcycle, stopped them and snatched away one money bag of the complainant containing of rupees 4,120 rupees, driving license, PAN card, one torchlight, key, mobile handset, SIM number so-and-so, mobile number, model number 16 so-and-so, one dot pen and one iCard. On the same day, after a couple of hours later, the complainant lodged the written Azahar with the police at Khuang, whereupon police registered the case under section 392 against 3 accused persons, appellants herein, and took up investigation. During the course of investigation, police says most of the stolen articles, including part of the stolen amount in cash. On completion of investigation, the police submitted charge sheet against all the 3 accused persons who stood trial under section 392 of IPC. During trial, when the charge framed and explained under Section 392 of IPC, all the accused person pleaded not guilty. Prosecution examined altogether 10 witnesses, including the IO. The accused person were examined under Section 3131B CRPC, and then their sentence were recorded. Accused denied that they had committed the offense as alleged. The defense case is of total denial. No evidence was adduced by the defense. On conclusion of the trial, the learned magistrate found the accused person guilty under Section 392 and convicted them accordingly and sentenced them as stated above. Aggrieved by their conviction and sentence, the accused appellants preferred this appeal. I have perused the impugned judgment and materials on record, heard the learned advocates for the appellants as well as for the respondents. As the evidence on record discloses, there are eyewitnesses' account of the occurrence and identification of the accused person by the victim complainant. Besides this, there is recovery of stolen articles from the prosecution of the accused appellants after the occurrence. Let me first deal with the evidence of PW1, Sri Deepak Bhawal, informant. He states that on 29/5/2008, around 8:30 at night, he was going to Kawanghat with his colleague Pankaj Paul to attend a marriage in the motorcycle. About the time while they were proceeding, another motorcycle came from behind and asked them to stop their motorcycle and switch off the light. One person sitting in the back side from the said motorcycle came down and searched him and took the torchlight. He also took a mobile handset from his front pocket and money bag from back pocket. They also searched his colleague and took his money bag. Thereafter, the accused person told him to leave the place. Then both of them went to Boga Dhaba and narrated the people there about the incident. The accused person also came there in motorcycle to the said place. But after witnessing them there, they speed away their motorcycle. On the same day, he filed the Azhar with the police. In cross-examination, he has admitted that the accused person were not known to him by their name, but he identified their face. The cross-examination part further reveals that he doesn't know the registration number of the motorcycle in which he was going with the colleague, which he is belong to his colleagues. He also doesn't know the registration number of other motorcycle. Details of the stolen articles were not mentioned in the FIR. He has identified all the three accused person in the court. Close on the heels of the witness PW2 Sri Pankaj Paul, colleague of PW1, and who was in the company of PW1 on the date of occurrence, has stated on the date of occurrence that he, along with his immediate senior PW1 Deepak Bhawal, was going to Kwang in the motorcycle, and before reaching the destination, they were stopped near highway near a petrol pump before reaching Kwang Tiniali. He identified two accused persons by pointing finger at them, namely Sri Debajit Gogoi and Sri Naba Chutia. His father evidenced that the accused Debajit Gogoi came riding a red-colored motorcycle from the same direction and stopped his motorcycle in front of their motorcycle, and then accused Nabachutia introduced himself as a police person. Asked him to show the driving license. When he was bringing out the driving license, accused Debajit took out the money bag, torch and mobile handset from the pocket of the PW1. Accused Nabachutia took out a purse from his back pocket and a money and cash of amount of rupees 100, 200, 1,240. Thereafter, the accused person left the place of occurrence and told them to go without switching the light on. Then the PW1, PW2 turned back and came to Boga Dhaba. On reaching there, they narrated the incident to the owner of the dhaba, Mr. Pinku. About that time, the accused Debajit Gogoi came from their riding motorcycle with other accused, Sri Naba Chutia and the another. On seeing them there, they have left the place and fled the scene. The owner of the dhaba identified the accused person and he went after them in mini truck but could not got them. PW1 and PW2 have remained consistent during the cross-examination and nothing has been brought to show that they were inimical towards the accused appellants. As such, I found no reason as to why their evidence should be discarded. PW3 Sri Gokul Gogoi, PW4 Sri Tankeswar Gogoi, PW5 Sri Palak Chutia, PW Sri Hanbar Chutia, PW7 Sri Nilamani Gogoi, PW8 Srimati Rima Gogoi, PW9 Sri Jivakanta Gogoi were examined as witness to the seizure of different articles alleged to be stolen away by the accused person. Let me deal with their evidence one by one. PW3 has deposed that the accused Navachitia and Debajit Gogoi are known to him. He has admitted his signature, Exhibit 3.1 on seizure list Exhibit 3, but in cross-examination, he has stated that he does not know the content of the seizure list, which is simply heard from the police about the incident of robbery. PW4 had deposed that one day police from Koang police station came to his house and took him to the house of the accused Norma Chutia and told him that accused is taken to the police station and asked him to put the signature on two papers, namely Exhibit 2 and Exhibit 3. In cross, he has stated that he put the signature on blank paper. PW5 has stated that one day in the morning, he saw police in the house of the accused Navachutia. Police took his signature, Exhibit 3, Clause 3 on Exhibit 3. He is not aware of the content of Exhibit 3. The rest of the seizure witnesses have also deposed almost in the similar manner. They have admitted their signature, but they do not know the content of the papers where their signature were taken by the police. According to the IO,
So
the
3 to 9, the seizure witnesses have not supported the seizure.
Yes, Lordship. They don't know the content, Lordship, but they have signed the paper.
Now, whether that would be fatal to the prosecution case or not, this is one thing which you have to show, right?
Yes,
Because I'm sorry, I read a little fast. So I have finished this part of the evidence. You can start from page 16.
Yes.
Sorry, 34, para 16, towards the end. Even if this is the finding of the court.
Paragraph 16,
Para 16,
Lordship.
read that.
Yes.
I have seen. So except the eyewitnesses of PW1 and PW2,
Yes, Lord.
there is nothing.
There's
The
nothing.
seizure list is also not been shown to the PW1 and
Wit-
2, that whether these are the stolen articles or not. And the seizure witnesses have not supported the seizure,
Yes.
correct?
Yes.
And this position, the appellate court admits.
Yes, Lordship.
Now read.
Yes, Lordship. The London magistrate has held that the subsequent recovery of the seizure of articles alleged to be taken away in the robbery are corroborative evidence. The offense of the robbery is complete as soon as the accused person took away the article from PW1 and PW2 belonging to them after restraining them on the road. The evidence of PW1 and PW2 is found to be trustworthy and reliable, who withstood the test of cross-examination. Even if the stolen articles are not recovered and the seizure list remain unproved, the evidence of PW1 and PW2 cannot be discarded on that
So this
ground.
is one challenge which you have to meet.
Yes, Lord.
Whether the finding of the trial court as well as the appellate court as regards your guilt purely by relying the evidence of PW1 and 2 can be faulted with.
Yes.
Because
Yes.
that appears, then that is a point of law.
Yes,
Because this court is not going to reappreciate these evidences.
yes, Lord.
So from evidence you cannot show because they are eyewitnesses and both the courts have said that yes, they are trustworthy.
Yes, yes, Lordship.
Now, because the seizure is not been proved, because the stolen articles was not shown, whether that is fatal to the prosecution case, making both the judgments perverse.
Yes, Lord.
Then of course, this revisional court will interfere. Otherwise, on facts, this revisional court is not going to interfere. I'm indicating my mind because
Yes,
this is
yes,
the
Lord.
argument you have to
Yes, Lordship. Yes.
meet with. Yes, read.
Yes, Lordship. In a case of robbery, it is not necessary to prove the recovery of seizure of stolen booty. Requirements of law is to prove the offense through cogent evidence, not the recovery of seizure list of the articles snatched away in the robbery. In the present case, though the IO could not have got the stolen articles allegedly snatched away by the accused person in the robbery, identified through the informant PW1 and his companion PW2. The IO failed to do so. The lapse on the part of the IO or amateurist investigation cannot be a ground to extend the benefit of such amateurist investigation to the accused unless the defense could show that it has caused prejudice to the accused person. In the case in hand, unproved seizure has not caused any prejudice to the accused person in their evidence. The evidence of PW 3 to 9 who have not supported the recovery of the seizure of the prosecution case cannot be a ground of disbelieving the evidence of PW 1 and PW 2 who are otherwise found reliable. The evidence of seizure witness is not so necessary to find out the truth. It is therefore not correct to say the evidence of PW1 and PW is valueless. Facts emerge from the above discussion leave.
All right.
For-
Now, what is the position of law?
Yes, Lordship. And another thing, Lordship, the identification of accused was done in the court itself, Lordship. The person who identified them, that owner of the Dhaba Rinku, he is not been examined by the IO, Lordship. Only that person also, only that identified the accused person. These are the accused person who has done the
What about PW 1 and 2?
Lordship PW what
They have said
they have said, Lordship, they have said they don't know the accused
by
person.
name.
Lordship,
By name.
by name, Lordship, yes. They have first seen them on the occurrence and then they have
Correct.
seen in the court.
Correct. So that is sufficient.
But they were been identified by the Rinku. That
Now,
is the
see, if this is one of your argument, then you have to give me case laws. One, whether because of non-examination of the witness who identified the accused, the prosecution case will fail, number one. Number two, whether the seizure list being not supported by the seizure witnesses in a case of robbery, whether that will make the prosecution case fail. These are things which you have to
that is there.
satisfy. So you have to show me the legal position. If you are
Yes.
having any authority.
Yes, Lord.
Are you carrying any authority today? If you are
Lordship,
not,
with-
then you
With regard to the identification, I have some judgment, but with regard to the seizure, Lordship, I have to go through one
then
side.
you'll go look into it. Because that is what,
Yes, Lordship.
because this court is not going to reappreciate PW1 and PW2. Both the courts have said that the evidence of PW1 and 2 is trustworthy, believable. Right?
Yes, Lordship.
Now, this is the finding. However, it appears that seizure list not true. Seizure witnesses do not support the seizure.
Yes, Lord.
Stolen articles, seized stolen articles not shown to PW1 and 2.
Not-
Whether these things would make the case of PW1 and 2 unbelievable and fatal to the prosecution. And also the fact that the accused were identified by someone else who is not also examined.
Yes.
You give me these case, whatever case laws you
Yes, yes.
find on this. When?
Lordship,
When do you want?
on
Ms.
next,
Mr. Locker, you are there in this case? You can also assist the court.
Lordship, regarding that aspect, Lordship, that whether non-producing of those articles.
Yes, because then the finding will become erroneous, isn't it? Otherwise, the finding, if,
One, two is sufficient. Usually 1 and 2 is sufficient, but
1 and 2 is sufficient, the trial court has said it's trustworthy, but it also appears that the Caesar witnesses have said
no, they have not
they have not
supported the case.
supported, and the stolen articles not shown. Now, in the context of a robbery case, whether that is required, not required, what is the law? You'll have to
yes.
Caesar witnesses have not stated that paper is blank or anything. They do. But
Correct.
they have stated that there
see,
is
the finding of the appellate court only is there.
Yes.
Appellate, you have not challenged that finding. Appellate court have said
So they have cited the blank.
the evidence, 1 second. Where is it said? Even if the stolen articles are not recovered and the Caesar list remains unproved, they have said it. In another paragraph, it is said that they have not. So then it becomes difficult. When?
Next Thursday. Next Thursday.
Heard MS N
M. Lordship.
M. Nirula, learned counsel appearing for the petitioner, also heard Mr.
PS law.
P.S. Locker, learned APP for the state respondent. Matter remains, hearing remains inconclusive.
On next Thursday. Lordship.
Next Thursday. Relist on such and such date for further hearing. Matter remains as part heard, huh? Part heard. Item 10, na, item? I shall just take a 5 minutes break.
Take up right now, my lord. I'm ready, my lord.
Okay.
Item number 4, my lord.
Okay. Arguments are over.
My lord. No, my lord, I
Arguments
just
are
pointed
over.
out very serious lacuna is in there here in this case. My lord, I'll just to point it out. Your lordship kindly see.
Your junior tried his best.
No, my lord. My lord, 1 point, my lord, your lordship kindly see the trial court judgment. In trial court judgment, my lord, main evidence of PW9, not even mentioned, my lord. Forget about consideration. Your lordship kindly see.
See, till I think the arguments on the last occasion, even
My lord.
for brief, we have this court also heard you. And then as your junior was developing, instead of going into the merit, he was saying,
My lord, that is
now, Mr. Locker, I have given a thought. And I think this is a case where maybe the appellate court ought to have done it. So since the appellate court has not done, I
360 benefit, there is no
Exercise.
discussion.
I'll do
And
that.
my lord, even revisional court and well,
Yes, I think you have shown me.
yes,
You have
no,
given
my
two
lord,
decisions of the
decision,
coordinate
my lord,
bench.
even my lord 360, my lord, proviso also
And
said.
I think on that day, you had also fairly submitted that.
Lordship.
So I can record that because I don't want to go into the merit there. Then
My-
without
my lord.
going into the merit, we can, isn't it?
Yes, that can be done.
That can be done.
No problem.
So my lord, then I have a.
There is no previous enmity in between them. Lordship.
Correct.
That is also
And
recorded, not.
there was no premeditated plan, no previous
No.
enmity, and there is nothing on record to show that
Major
he
injuries are not there. Lordship.
that
Nothing is
he's
there.
also involved in some other.
Lordship.
There is nothing on record, isn't it?
Snatching of snatching something that is also not.
I have made, my lord, your lordship can, my lord, go.
All right.
My lord.
Appreciate it.
So that's all, my lord.
You, if in case you have any other engagement, your junior is there. It is up to you.
No,
I'll dictate it now only.
no, now, my lord, I'm ready. I am up to 1 o'clock, my lord, I am free. But 2 o'clock, a matter is
No
fixed by the
problem.
Supreme.
All right, take your seats.
My lord.
Heard Mr. T.J. Mohanto, learned senior counsel, assisted by Mr.
T Gogoi.
T.
Gogoi.
T. Gogoi. I'll put his name or your name for hearing.
It'll be, if your lordship allow my lord his name, my lord. No, my lord, nowadays, my lord, there is a difficulty, my lord. Everything, my lord, all online, everything, my lord, look, my lord. That is the problem, my lord. In my lord, in one case, my lord, but two side, my lord, arguing as a cooperative matter, my lord. But I came to know, my lord, in village, my lord, both side, my lord, in a school, in a big skin there, and
They were watching.
they are watching, my lord.
Good to know that litigants are becoming aware of
Beware of, my lord.
the cases, what is going on.
Both the side, my lord, in a school, both side were in the same
The
campus.
problem arises when they misunderstand.
Yes,
because
my
they
lord.
are not familiar with the
Yes, my
court
lord.
proceedings.
Yes, yes.
So there are certain times you may not have to make any submission. Then they are
Exactly,
like,
yeah.
why my counsel has not?
And sometimes,
That
my
is
lord,
where the problem comes.
sometimes with a lighter when we are discussing something, that my lord goes, my lord, in a
Correct.
viral in different way.
These are pros
These
and
are, my lord,
cons.
my lord, negative side, my lord.
Yes, but
My lord.
anyway. Also heard Mr. P.H. Locker, learned APP for the state respondent. Stop. This application is under Section 401, read with Section 397 of the Code of Criminal Procedure, 1973, challenging the judgment and order. Both the judgments you have challenged?
Yes, my lord.
Challenging the judgment and order dated 22/8/2008, passed by the learned Chief Judicial Magistrate Guwahati in GR case number
Golaghat, my lord.
5 stroke, sorry,
Yes,
Golaghat, in GR case number 5 stroke 2007, hereinafter referred to as the Magistrate Court, whereby the petitioners were convicted under section 341, 323, 34 of IPC and sentenced to pay rupees 400 each under section 341 of IPC in default payment of fine, in default simple imprisonment for 15 days and also rigorous imprisonment for 3 months each and fine of rupees 500 each under section 323 of the IPC. In default of payment of fine, simple imprisonment for 15 days. And judgment and order dated 13/7/2012, passed in criminal appeal number 42/2008, passed by the learned session judge Golaghat, hereinafter referred to as the appellate court, whereby the appeal preferred by the petitioners was dismissed. Stop. The brief facts of the case is that on 1/1/2007, one Pradyut Hajorika is the
Informant.
informant, isn't it?
Pradyut Hajorika, PW1.
He is not made a respondent here. One Sri Pradyut Hajorika had within bracket Didiba informant had lodged an FIR at the Kyle police outpost alleging inter alia that on the same day at around 3:30 p.m. while he along with his friends were on their way to his petrol pump at Kuralguri, one jeep in which around 5 to 6 persons came towards them and did not let them cross. Therefore, they had to stop their vehicle by the side of the road. It is further alleged that when they stopped at the side of the road, a boy came down from the said jeep and had administered a punch on the right eye of one of his friend, for which his friend had sustained serious injury. Thereafter, his another companion, in Naam Gita Kuriya Bhanegi, one of his friend being Indrajit Neog. Thereafter, his another companion being Rajesh Agarwala was also assaulted by them, for which Rajesh Agarwala lost his mobile phone. It is further alleged that thereafter they had been taken to a house nearby and were being confined there, from where later on the police rescued them. Stop. The FIR was accordingly registered under section under as Golaghat PS case number 4 of 2007 under section 147, 325, 342 of IPC. Upon investigation being completed, the investigating officer submitted the charge sheet under section 147, 325, 342 of IPC against the accused petitioners. Thereafter, the child was okay. No, wait. Thereafter, the accused petitioner appeared before the magistrate court, whereafter the magistrate court framed charges under section 341, 323, 34 of IPC and conducted the trial. After conclusion of the trial, during trial, prosecution examined as many as 9 witnesses in support of their case and defense examined none. After completion of trial and upon hearing both the parties, the learned Chief Judicial Magistrate Golaghat, by judgment and order dated 22/8/2008, passed convicted the petitioners under section 341, 323, 34 of IPC and sentenced them thereof. Being aggrieved, the petitioners filed an appeal before the appellate court, wherein the appellate court was pleased to dismiss the appeal and upheld the conviction and sentence passed by the magistrate. Stop. Situated thus, the present revision petition has been filed. Stop. Mr. T.J. Mohanta, learned senior counsel, submits that he is not arguing the matter on merit of the conviction and shall confine his submission in the appeal only in respect of the order of sentence. Mr. Mohanta?
Yes, correct.
He further submits that the petitioners has not been convicted previously for any offense and he is a first-time offender. Stop. He further submits that the offense appears to have been committed in the heat of the moment and the petitioners did not know the informant stroke victims prior to the incident. He further submits that it has also come out from the evidence that after the incident, the accused had the petitioners, one of the petitioners had taken the accused, taken the victims to their to the house where water was also given. He further submits that
Injuries are simple in nature.
that the injuries are also simple in nature. Stop. Therefore, in the aforesaid backdrop, he submits that the magistrate court ought to have considered granting benefit of provision of the Probation of Offenders Act 1958 to the accused. However, the same was he took it, yeah. He further, therefore, in the backdrop, in the aforesaid backdrop, he submits that the benefit of section 360 of CRPC stroke Probation of Offenders Act, 1958, hereinafter referred to as the Act 1958, ought to have been given in the facts and circumstances of the case, or the petitioners ought to have been punished only with fine as permissible under section 323 of the IPC. Stop. He further submits that the magistrate court, while rejecting the benefit under section 360 CRPC, did not consider the factors favorable to the petitioners. He further submits that in the appellate court judgments, there is no any discussion about the granting benefit of section 360 of CRPC stroke Act 1958. Stop. In support of the aforesaid submissions, he relies the following decisions. Number 1, 2012, volume 9, SSC 460. Number 2, AI 2005, Supreme Court 3534. Number 3, Ratul Bhuya versus State of Assam in criminal revision petition number 383 of 2012. Number 4, Abdur Rahman Mandal and others versus State of Assam in criminal revision petition number 273 of 2009. A dutale likhe diba, passed by the Guwahati High Court. So, per contra, Mr. P.H. Locker, learned APP, also in his usual fairness, submits that though the magistrate court has held the injury to be simple in nature, yet has mechanically rejected the prayer under the Act 1958 and Section 360 of CRPC. Stop. Correct? Because I remember you have said that.
Because there is no any previous enmity was there, Lordship.
Correct.
it happened only.
He further says that he further submits that that
Lack of evidence.
it is clearly discernible from the evidence that there was no previous enmity between the petitioners and the informant stroke victims, and
it happens at the head of the moment and
he,
it happens.
I think that is sufficient. That heat of moment,
That's-
Mr. Mohanta is also submitted. I have given my anxious consideration to the, no, I'll generate into my due. I have given my prudent consideration to the arguments advanced by the learned counsels for both the contending parties and have perused the materials available on record. I have also considered the case law submitted at the bar. This court, upon after perusal of the materials available on record, has also has not found any patent error or illegality in passing the judgment. It appears that the arguments of both the sides is as regards the benefit provided under section 360 of CRPC and the Act 1958. Therefore, without going into the merits of this case and any further, this court will now deal with the entitlement of the petitioner of the benefit under the Act 1958. Stop. Apt to refer to section 360 of CRPC, which reads as hereunder, quote unquote. Apt also to refer to section Probation of Offenders Act. Section 4. Ase, you have a copy? Where it is written, the High Court in the revision, that is in 340, 360.
My lord.
That the court, even appellate court and revisional court, that part that you had showed me on the other day, that is in 360.
Subsection 4.
360, right?
360 subsection 4.
Reading of section 360 of CRPC, subsection 4, it appears that
An order under this section may be made by the appellate court or by the high court or by the session court or by existing power.
subsection 4,
4, my lord.
340,
360.
360, sorry. Yes. That an order under section 360 directing release of an accused person on probation of good conduct or other or after admonition can also be made by any appellate court or by the High Court or Court of Session when exercising its powers of revision.
That is supported by the 2005-13.
Reference in this regard is made to the decision of the Apex Court
2005-13 SCC is
in the
110.
case of Ram Paswan versus State of Bihar, Supra, wherein para
8 last portion, my lord.
a copy to us.
But I have given the judgment, my lord. I know this is the judgment.
Judgment you have not given.
Anyway, my lord,
Okay.
it is very clear in this. Para 8 last part,
Judgment
last.
লিখলে নাকি আগতে? Chapter 9 more copy.
Para 8 last line, man.
Para 8 is quoted, paragraph 8 of the aforesaid judgment is reproduced here. Reading of the aforesaid judgment, it is clear that the power under section 360 and section 4 of the Act 1958 can be exercised by the courts while finding the person guilty, and if the court thinks that having regard to the circumstances of the case, including the nature of the offense and the character of the offender, benefit should be extended to the accused. The power can be exercised by the court even at the appellate or revisional stage, and also by this court while hearing the appeal and revisional stage. Full stop. Full stop. Okay. ইয়াৰ ওপৰত এইটো লগাই দিবা হা, apt to refer to section 4 of the Act 1958 which is reproduced, সেইটো ওপৰত কৈ দিবা, and তাৰ পিছত reading of the aforesaid provisions বুলি। Which is the other case, Supreme Court, you are replying them, Amit Kapoor.
Amit Kapoor, my lord.
12, 13 and 18, your reference is also made. No, this is in relation to revisional jurisdiction.
Revision.
This may not be needed, I think.
That is, my lord, considering those, my lord, they are High Court judgment.
Yes, yes, I'm coming to that. I'm coming to
Yes.
that. Reference is also made to the decision of the subordinate bench in the case of Ratul Bhuiya Supra. Wherein this court, in exercise of revisional power,
Para 18, my lord.
I will. After considering the nature of the offense in the facts of that case, gave the benefit of the 1958 Act of 1958 to the petitioners. Stop. Paragraph 16, 17
And 18.
18 is of the aforesaid judgment is reproduced here under for ready reference. Okay? Stop. I think one is okay, the other one
my
is
lord,
the
that's
same.
Court judgment I have
Yes,
already quoted, my lord.
In the present case, it appears that the alleged offense was committed on 1/1/2007 and the
18 years done.
and it is crystal clear from the judgment and order of the trial court that the offense is not considered as heinous or premeditated. Stop. It appears that upon sudden quarrel between the petitioners and the victim on the road, the petitioners have committed, the petitioner dealt the blow. Stop. It is further apparent that the petitioners have not committed any similar nature of offense in any point of law. That is, they have no past criminal records. It further appears that the petitioners have been suffering since last 18 years, litigating in the court due to the alleged incident which was happened in the year 2007 when they were young boys. It further appears that injury are simple in nature and there is no previous criminal background of the petitioners as revealed from the trial court judgment, and occurrence took place due to the understanding. Stop. Now, apt to reproduce. Trial court judgment is at what page? 11. That paragraph, that simple injury paragraph.
Paragraph 15, my lord.
Hmm?
Paragraph 15, my lord.
Paragraph 15.
Regarding injury, my lord.
Yes, yes.
Injury
where
is
he's-
simple. The last line of the para 15, my lord.
Paragraph 15.
I hold that the injuries were simple in
Yes,
nature.
yes. Paragraph.
15, last line, my lord.
Yes. Paragraph 15, paragraph 15, quote unquote, page 15.
I
Then
hold that the injury were simple in nature.
Then- paragraph 26 to quote kore diba. Huh? Reading of the aforesaid paragraphs of the judgment of the magistrate court. Magistrate court on jagat here in a trial court kore diba. Of the trial court, it appears that though the trial court has held the injury simple, comma, was observed, no, observed that the benefit of release on probation of good conduct under section 4 of the Act 1958 cannot be extended to the petitioners. It further appears that considering the fact that it further appears that the trial court, by considering the fact that the accused persons were not habituated offenders, and since they were not proved to have been convicted earlier, they were sentenced to fine of rupees 400 each under section 341 IPC. In default of payment of fine, simple imprisonment for 15 days, and also sentenced to rigorous imprisonment for 3 months each and fine of 500 each under section 323 IPC. In default of payment of fine, simple imprisonment for 15 days. It further appears, it appears that the appellate court, while appellate court, it is thus apparent that the relevant factors for considering extending the benefit of section 4 of the Act 1958 and section 360 CRPC was the reasons for the reasons for rejecting the benefit of so and so was not reflected in the judgment of the trial court. On the contrary, the trial court has clearly recorded that the petitioners are not habitual offenders and the nature of injury is simple, and that the petitioners were not convicted in any other offense, in any other criminal case. Stop. Perusal of the appellate court's judgment, it appears that despite the appellate court having the powers to give the benefit of section 360 CRPC and the revisional and section 4 of the Act 1958, did not consider the same. Stop. It is thus apparent that the that though the trial court exercised its discretion under the Act 1958, however, it did not cite any reason for rejection of such benefit. In the considered opinion of this court, such is a failure of exercise of jurisdiction by the learned trial court below. In a court may not grant benefit in the given facts of the case. However, consideration must be given. Considering the above stated facts and without entering into the merits of the judgment impugned, and considering the relevant provisions and settled propositions of law and the period lapsed from the date of incident, and also that the incident occurred without any premeditation or and that there was no previous and that they did not know each other. Premeditation, without any premeditation in mind, and that the punishment awarded for the offenses, comma, I am of the considered opinion that this is a fit case where the benefit of provisions of the Act 1958 should be provided to the accused petitioners by this court in exercise of its revisional power. Accordingly, for the reasons recorded herein above, the petitioners, what are their names? Sri Rajiv Gogoi, Bubul Soikya, and Purnananda Gohai is given benefit under the Act 1958 and sentence is modified to the effect, and it is provided that instead of sending the petitioners to jail, they should be given they should be given the benefit of Section 4 of the so and so. Accordingly, it is directed that the fine let them give.
No, my lord, provision of offender act, then they have to sign, they have to, my lord, execute a bond for peace and good behavior for one.
Accordingly, it is directed that the petitioners will file 2 sureties to the tune of 20,000.
10,000, my lord.
20,000 along with personal bond before the trial court, i.e. trial court is and undertake to the effect that the petitioner shall remain peace and good behavior during the period of 1 year,
1 year from today.
1 year from today. But what was the imprisonment? I think 3 months.
My lord.
Imprisonment was 3 months.
3 months.
So then 3 months or 1 year?
Yes, in this case, 3 months.
Correct. So 3 months.
My lord.
3 months was jail.
3 months. During the period of 3 months from today?
My lord. Period is not mentioned, my lord, in Act.
Yes, yes. I was just checking that.
Not much.
All right. the aforesaid bond to be filed by the petitioners within a period of 2 months from the date of this judgment. With the aforesaid, the revision petitions is
Deeply appreciated.
allowed. Before parting with the case, this court deems appropriate to appreciate the assistance and argument made by Mr.
T Gogoi.
T.
Yes.
By T.
Torun
Gogoi,
Gogoi, his name is.
Mr. T. Gogoi, learned counsel, assisting Mr. T.J. Mohanton, learned counsel for the petitioner.
Deeply appreciated.
That being item number 8.
দুখন আহিলে এখন তেওঁলোকৰ এক ঘূৰাই দিব আমাৰখন কোনখন চাব লাগিব এইখন মোক লাগিব। This is item number 4 আছে না আমাৰ এইটো হৈ গ'ল display 8
May please. Lord, this revision petition is against the, my lord, judgment and order dated 21/2/2011, my lord, passed by the learned session judge Zorat in criminal appeal number 28 of 2010. Convictions, my lord, under section 279, 304A and 337 IPC, my lord. Date of occurrence is, my lord, 23/8/2007. FIR lodged by the, my lord, SI of Police Zorat. Allegations is, my lord, if one Arifa Khatun, my lord, while carrying her younger sisters, Armina Khatun, in the carrier of a bicycle, my lord, by pushing and proceeding from DTO's office Zorat to DCB school. The truck run by the, my lord, appellant, my lord, hit from behind, my lord, and as a result of which the sisters of the, my lord, Arifa Khatun, that is Armina Khatun, fell down and she died. And the Arifa Khatun also got injuries in this left leg. Now, lordships, the prosecution has examined, my lord, 8 witnesses, including the doctor and the IO. Now, lordships will find the PW1. In the my whole submission is that, my lord, none of the, my lord, prosecution witness has deposed before the, my lord, trial court as regards the rashness and negligence driving of the vehicle by the appellant, my lord. And that is also, my lord, in our one of the decisions of our High Court, my lord, held that in absence of, my lord, any specific depositions by any prosecution witness, my lord, the convictions cannot be, my lord, sustainable, my lord. Now, lordships, if evidence of the, my lord, PW1.
Evidence will not go at this divisional stage. You first show me the appellate court judgment.
Yes, ma'am. Appellate court judgment, lordships, will find starts at page 29.
Yes.
But the findings, lordships, will file after the.
We'll go to finding first. Let us understand what the case is.
Yes,
Part
my lord.
2, you may read.
Yes, my lord, I may be allowed to read that. Paragraph 1, my lord.
Paragraph 2,
Paragraph 2.
page 30.
Yes, my lord. The prosecution case in brief is that of 23/8/2007 at about 9:40 AM, Srimati Arifa Khatun with her younger sister Armina Khatun as a pillion rider was proceeding on a bicycle from the side of DTO's office towards DCB school. The truck driven by the accused Kalu Singh alias Kuldeep Singh hit the bicycle from its behind. Mrs. Arnima Khatun fell down from the bicycle and left side of rear wheel of the truck ran her, causing her death on the spot.
Mr. Sharma, one second. Yes.
After the Armina Khatun sustained fractures on her right leg, the bicycle was also damaged. After the accident, the accused Kalu Singh fled away with his vehicle. SI Durlabh Medi lodged the formal FIR. A case was registered and on completion of investigation, search sheet against the accused was submitted under section 279, 338, 304A of IPC. During the trial, 8 witnesses were examined by the prosecution. No defense evidence was adduced. The accused in his statement under section 313 of CRPC denied the allegations leveled against him. The learned trial court on conclusions of trial found accused guilty under section 279, 304A, 337 IPC. He was accordingly convicted and sentenced as stated earlier. Srimati Arifa Khatun, PW1, is one of the victims. She deposed that she was carrying her younger sister on a bicycle by pushing the bicycle on road. The truck hit the bicycle from its behind. Her sister fell down and she was crashed under the wheel of the truck. She stated that the offending vehicle number so-and-so was driven by the accused Kalu Singh alias Kuldeep Singh. She also sustained injury. She denied in her cross-examination.
Mr. Sharma, at 2.
My lord, my. All right.
Turn up next Thursday, my lord. I have some problem today.
Item 9.
Item 9.
Okay. As prayed form by Mr. A.R. Sikdar, learned counsel for the petitioner, which is not opposed by the other side, relist, not next Thursday. After the
Mal. May I please, your lordship, my lord? My lord, I beg to mention item number 19, my lord. I am for the petitioner, my lord. The other side is there, my lord. I was about to get the instruction whether the petitioner is paying the monthly maintenance of
other
rupees
side is
5,000.
there.
Yes,
You are there.
No,
Just
I
2
have
weeks
the
time may can be
instruction,
granted.
your lordship.
Huh?
He is paying, your lordship, though the amount less.
Just 2 weeks time may can
All
be
right.
granted.
As prayed for by Mr.
Zed Ahmad, my lord.
Jed Ahmed Hamad,
My lord.
learned counsel for the petitioner, which is not opposed by MS MB Borwa, learned legal aid counsel. Relist this matter after 1
After
week,
Bihu.
2 weeks.
Not before Bihu, your lordship.
Okay.
Might be.
Release on such and such date to enable Mr. Jed Hamad, learned counsel for the petitioner to obtain.
As to the petitioner is paying the monthly maintenance of rupees 5,000
That
only.
she said is paying
Yes, but
So,
certain
less,
instructions, my lord, required, my lord.
to obtain instruction as regards the payment of maintenance.
My lord.
10th April, 8th April, no, much of.
Much obliged.
If you were reading
My lord,
the
affiliate
evidence
judgment.
part from
Yes.
PW1,
My lord. Page 31, my lord.
page
31.
yes.
I'm reading the para 4 or 5, my lord.
Yes,
Para 5, my lord.
yes. Yes, please read.
Yes. Sri Rajiv Dutta, PW2, corroborating the evidence of PW1, stated that the truck driven by the accused was in excessive speed. That lordship may mark that part. Excessive speed and hit the bicycle. One of the victim died on the spot and another sustained injury.
This is negligent drive.
Yes, allegations. The driver of the truck ran away after the accident and the inquest on the dead body of the deceased was held in his presence. He denied that he did not state before the police that he saw the accident. And Mohammed Fulbar Ali PW3 saw the victim's proceedings on bicycle by the side of road. He also saw the accident. He has his own PCO near the place of occurrence. He also identified the accused as driver of the vehicle. Sri Rajan Hazarika, PW4, corroborating the evidence of PW1, stated that the victims were on their own side of the road and bicycle was pushed by one of the victims. The truck hit them from behind and the truck crashed one of the victims. He, however, did not notice who was the driver of the vehicle. Sri Ratul Borthakur, PW5, could not say for whose fault the accident occurred. Dr. Buddhadev Dutta, PW6, held the postmortem examinations on the dead body of the deceased and his findings are as follows. The deceased died due to coma as a result of injuries sustained, that the injuries were crush injury over the head with expulsions of the brain matters which were lacerated, scalp congested, both the partial and occipital bones were fractured. All the injuries were antemortem. He was not cross-examined by the defense. PW7 is the investigating officer of the case. Dr. Gautam Hazarika, PW8, examined the victim, Arifa Khatun, on 23/8/2007. He found one swelling and tenderness over the right foot. According to him, the injury was fresh, simple, and caused by blunt object. He admitted in his cross-examination that such type of injuries might be caused by fail on hard substance. In this case, the factum of accident is not denied. It is also an admitted fact that the accused was driving the truck and one of the victims died due to the accident and the other sustained injury. The defense case, as it appears from the cross-examination, is that the driver accused was not negligent and the accident occurred due to his rash and negligent driving. From the trend of evidence and cross-examination, it transpires that the victims were on left hand side of the road. The truck hit them from their behind. One of the victims were crushed by the wheel of the truck while another sustained injury. The accident was witnessed by PW1, PW2, PW3, and PW4. There is no evidence that the accused tried to avoid the accident by applying brake or by blowing horn. On the contrary, there is evidence that he was driving the truck in excessive speed. I therefore find that the trial court committed no wrong convicting the accused appellant under section 279, 3048, 377 of the IPC. I find that the appeal is devoid of merit. Accordingly, it is dismissed. There is surrender before this court. Now, the learned appellate court, my lord, find that only the excessive speed, that is the only deposition deposed by the prosecution witnesses. But there is no any evidence, my lord, and there is no any prosecution witness deposed that there is.
What is this PW 2? No, but PW1 have said stated that the truck driven by the accused was in excessive speed and hit the bicycle.
Excessive speed is there, my lord.
Yes, then
But my lord, the rashness and negligence is missing.
what do you mean by excessive speed?
But that is, my lord.
What is rash and
Yes,
negligent?
that is my lord.
And if there was no brake,
Yes.
the evidence says that you see, Mr. Sharma,
My lord.
I am exercising the jurisdiction of a revisional.
My lord.
So I cannot now weigh the sufficiency of these evidences.
But that part.
If you bring out a case of no evidence, if suppose the word excessive is not mentioned anywhere, and the trial court have simply assumed that excessive speed, then certainly it will be perverse. But PW2 have said, and PW1 have also said, that she was carrying her younger sister on a bicycle by pushing the bicycle on road. The truck hit the bicycle from its behind. Her sister fell down and she was crushed under the wheel of the truck.
But excessive speed is, my lord, deposed.
PW2 have said?
Yes, my lord, but the.
Not necessary. All the witnesses have to say that.
No, I am not.
One of the witnesses
Yes,
said
my
it.
excessive.
And you have not shaken this witness during cross. Now, whether sufficiency and all that, this court cannot go unless you point out that the order, there has been ignorant of a particular provision, the law has been ignorant, and therefore there is a manifest patent error.
Yes, my lord.
Because appellate, you see, concurrent finding is there.
Yes, concurrent.
Right.
Yes.
Appellate court has appreciated the findings of the trial court.
And that excessive speed part, my lord, that has already been, my lord, discussed in one of the.
Let's go back to the trial court.
Yes.
And PW4 stated that the victims were on the one side of the road and the bicycle was passed by one of the victims. The truck hit them from their behind and the truck crashed.
But PW4, my lord, in the cross, my lord, says that the truck or backside lagi swali pori jai. My lord, the backside of the truck, my lord.
The truck hit them from their behind and the truck
my lord,
crashed one of the victims.
I have the certified copy of that, my lord, evidence, my lord. In the cross, my lord.
whether this side or that side, it was coming in excessive speed.
But my lord, that part of the my lord excessive speech, my lord, as my lord already been
Finding
discussed.
of fact,
Yes, finding of fact.
finding of fact, Mr. Sharma.
Yes, my lord. But my lord, I am relying on judgment of
Yes,
this
yes,
honorable
of
court.
course, please give.
That,
What page do I get the trial court order?
trial court judgment, my lord,
Yes,
that lordship will find.
page 11.
It starts at page 11, my lord.
We have the discussions,
Discuss on the
page 10.
para 10, my lord, there the evidence part is discussed, my lord. And lordship will find 30 page, paragraph 30, page 22.
Page
22, para 30, my lord.
22.
Yes, page 22, paragraph 30. Management.
Yes, please read.
Yes, my lord. Now therefore, let us carefully scrutinize the evidence of the investigating officer. The exhibit 4 site plan shows that the truck hit the bicycle from behind on the left side of the road. The investigating officer has stated in the exhibit 4 site plan that there was no skid mark on the road. This proves that the truck hit the girls who were proceeding ahead of it on a bicycle on the left side of the road from behind, and the driver did not even apply the brake or try to save the serve the truck to the right side of the avoid the accident. In the exhibit 7, in inspections report, the inspector of motor vehicle Jorat has stated that at the time of inspections, he found the truck bearing registration number so and so mechanically in good conditions. In view of the above testimonies of the prosecution's witness, it must be held that the alleged accident was caused due to rash and negligent driving of the truck bearing registration number so and so by the accused Kalu Singh alias Kuldeep Singh, which caused the death of Armina Khatun and hurt to Arifa Khatun, which are offences under section 279304A 367 IPC, and hence the accused must be held guilty of committing the said offence. Therefore, the point number so and so is decided. Para 32, causing any damage by rash and negligent driving cannot be held to be committing mischiefs, thereby as per definition of mischiefs given in section 425 ITC. But if rash and negligence driving can be imputed with the knowledge that by such driving the driver is likely to cause any wrongful loss or damage to any persons, though he may not have any intention to cause wrongful loss or damage to any persons, he may be held to have committed an offence under section 425 IPC, which is punishable under section 427 IPC. In the case in hand, except hitting down the girls by his rash and negligent driving of the truck, the accused cannot be held to have any knowledge that by his said act he was likely to cause any wrongful loss or damage to any persons. Therefore, even if
Very well rendered judgment of the trial. Sorry, Mr. Sharma.
my lord, but my lord, I am
Give me
relying.
that judgment.
Yes, my lord.
Marwa,
This is judgment.
this is judgment. Oh, sorry.
I am reading. It is reported in 2005 to GLT 274. Relying on my lord.
Coordinate bench. Coordinate bench.
Yes.
Yes,
Para 12, 13, and 15.
yes.
Married, my lord. Para
Yes.
12. In the light of the aforesaid
What is
evidence,
the law?
my lord, here, my lord, the only this honorable court held that there must be, my lord, harass and negligence driving.
Excessive speed.
Not excessive speed, my lord. Is Para 13. I am reading, my lord.
This is a coordinate bench judgment.
Yes,
I am of the view excessive speed.
my lord. I am reading, my lord. That is discussed, my lord. Here. In the light of the aforesaid evidence of the prosecution witness, we are to see whether the prosecution has failed to discharge its burden to prove the offence under section 279304 IPC beyond reasonable doubt or not. In order to find a person guilty under section 279 IPC, prosecution is to establish that the accused is driving the vehicle in a public way and that he was driving in a rash and negligent manner. Similarly, to constitute offence under section 304A IPC, the prosecution is to establish the rash and negligent act.
Here, there is evidence that you did not press the brake.
Madam?
In your
brake,
case,
yes,
there
yes.
is an evidence that you did not press the brake.
Yes,
If you would have pressed the brake, you could have prevented. You could have taken the precaution. You did not. Mr. Sharma, the judgments of the courts has to apply to the context of each case.
facts and circumstances.
Correct. In the facts of this, you cannot simply say that this case is applicable when the facts are different.
Facts are different,
In
but law, my lord. So
Law is,
Yes.
there is no quarrel. There is no quarrel to the proposition that the rash and negligence has to be proved. There is no quarrel to that
but
proposition.
excessive speed, my lord, how much
See,
it is,
you
my lord,
see,
excessive?
Mr. Sharma, excessive speed,
But because it is the highway, my lord. So,
excessive speed plus not pressing brake.
but my lord, it is highway, my lord. So,
Sorry.
my lord, in lordship, once
Yes,
again,
yes.
para 13, my lord.
Yes.
My lord. Para 13, my lord. May I read, my lord? In order to
Yes.
convict a person under section 279 IPC, the following ingredients are to be proved.
Before that, on the other hand, negligence is in this only I am
In
reading.
the para
Ah.
12, my lord. Yes. On the other hand, negligence.
Rashness is an act done in the hope that no untoward consequence will ensure, though the person is aware of the likelihood of such consequence. On the other hand, negligence is acting with the awareness that
That
harmful or
harmful and-
mischievous consequences will follow.
If a person,
If a person doesn't act with utter indifference of the consequence, or which he may be conscious, which he hopes may not take place, he is said to be rash. Negligence is failure to take that precaution which a reasonable and prudent person is expected to take.
even if an act is found to
Even
be
if an act is found to be negligent, it may not be considered to mean as rash in a given case. Culpable rashness is acting with consciousness that mischievous consequences are likely to follow. When he have seen these two girls going in a bicycle, why he did not press the brake? Is he not aware or is he not conscious that not pressing that brake is going to cause injury?
that part is.
That's why I'm saying there is no quarrel to, I fully appreciate your arguments, but it has to be applied to the facts of each case. And I am exercising revisional jurisdiction, even if I have two views.
Ah.
Is that a ground for interfering? You know,
Yes.
is that a ground for interfering?
Well, for a moment, my lord,
Yes.
my lord, yeah. In order to convict a person under section 279 IPC, the following ingredients are to be proved: that the accused was driving the vehicle, that the accused was driving the vehicle on a public way, that the accused was driving the vehicle rashly and or negligently.
No, before that, you are missing the main thing.
In para 12, last part.
Last part, criminality lies in not taking the precaution to prevent the happening of the consequences in the hope that they may not happen.
Yes.
That is where
Break.
I'm pointing out repeatedly. This is where, if that part was also not there, I could have thought otherwise. It is clearly there. Otherwise, there is no, because you see, in the end, there is no iota of evidence regarding rashness or culpable negligence of the driver of the truck, either in the statement of the eyewitness or other witnesses. And how can you say that this is applicable in your case? The law is not, there's no difficulty in accepting the law that is laid down in this decision. Take down. You want to add anything?
That much because lordship, that map trace map has been exhibited, lordship, And here also that is there is no no skid mark, Lordship, that is no skid mark.
Yes, I have
Lordship.
noted.
And
I have noted.
it has also been stated here, Lordship, that Lordship only 3 feet. See, that vehicle was there and the bicycle was under the vehicle. It is only 3 feet, Lordship. So 3 feet distance. 3 feet distance means this is the distance. So they were on the right.
Not going to, I'm not going to reappreciate these evidences. It appears
So Lordship, 1, 2, 3, 4, 7. IO is also
One,
material evidence in
2,
this case.
3, 4.
4 and 7 is the IO, Lordship. His evidence
All
is
right,
also
you
Lordship.
help me when I'll come to your submission, then you formulate what you want to submit, I will add it. Okay. Item number 8, huh? Okay. Heard Mr. R. Sharma, learned counsel appearing for the petitioner. Stop. Also heard Mr. P.H. Locker, learned APP for the
P.S.
state
Locker.
P.S. Locker, learned APP for the state respondent. This revision petition is directed against the judgment and order dated 21/2/2011 passed by the Session Judge Jorhat, hereinafter referred to as the Appellate Court, in Criminal Appeal number 28 of 2010, whereby the appeal filed by the petitioner was allowed,
Dismissed.
was dismissed, and the judgment and order dated 27/8/2010 passed by the Chief Judicial Magistrate Jorhat, hereinafter referred to as the Trial Court, in GR case number 1020/2007, whereby the petitioners were convicted under sections 279/304 capital A/337 of the IPC. Stop. The facts of the case is that who lodged the FIR?
SIO Police Matter Jorhat.
That the jurisdictional police officer lodged an FIR on 23/8/2007, stating inter alia that it was learned that on that day at about 9:40 AM on the Gorali in front of the Punjab Engineering, while one Arifa Khatun was riding a bicycle carrying her younger sister Armina Khatun, and was proceeding towards DCP school, a truck bearing registration number AMS 5938 at a very high speed and in a rash and negligent manner, driven by the accused petitioner, hit them from behind, as a result of which Armina Khatun fell down from the bicycle and the left side rear wheel of the truck ran over her head, killing her on the spot. It is further alleged that Arifa Khatun also sustained fracture injury on her right leg, and the bicycle was totally damaged. It is further alleged that the accused fled away from the place of occurrence by leaving the truck. Accordingly, the FIR was registered under section 279-338-304 capital A 427 IPC. And thereafter, charge sheet was filed under section 279-338-304 capital A 427 IPC, correct?
337.
Sorry. And after completion of investigation, the investigating officer filed charge sheet under section 279-337-304 capital A 427 IPC against two petitioners,
No, one.
against the petitioner number 1 and
Only?
the co-accused.
No, my lord, only one.
Against the petitioner accused. Upon conclusion of the trial, during trial, not during trial, thereafter, the trial court framed what charges? Same.
Same, sir.
Thereafter, the trial was conducted wherein the prosecution examined as many as 8 witnesses, whereas the accused petitioner did not examine with any witnesses except his statement under section 313 CRPC, wherein he has denied the prosecution case and has stated that the allegations leveled against him are false and baseless. Stop. After conclusion of the trial, the learned trial court was pleased to hold the petitioner guilty under section 279,
337.
comma 3.
337.
What about 304?
304 is there.
Comma 304 capital A and
427 is not there, my lord.
and 337 IPC. Being aggrieved by the aforesaid judgment in order of the trial court, the accused petitioner filed an appeal, being Criminal Appeal number 28 of 2010 before the appellate court, wherein the appellate court, after analyzing and reappreciating the evidences, was pleased to dismiss the said appeal. Situated thus, the present revision petition has been filed. Mr. R. Sharma, learned counsel for the petitioner, submits that there being no evidence as regards rash and negligent driving, the judgment in order of both the appellate court as well as the trial court is totally perverse. Stop. He further submits that in order to prove rash and negligent, comma. He further submits that in order to constitute an offense under section 279/304 capital A, the proof of rashness or negligence is essential. Stop. In support of the aforesaid submissions, he relied upon the decision of the coordinate bench of this court in the case of Kirti Singh versus State of Assam, reported in 2005, volume 2, GLT, at page 274. Correct?
Yes.
That's all. For contra, Mr. P. S. Locker, learned APP for the state respondent, submits that it has clearly come out from the testimonies of PW 1, 2, 3, 4, and 7, and the exhibits, especially
Exhibit 4.
especially the
Exhibit 4 also.
especially exhibit 4, which is the
That is the trace map also.
trace map that the accused petitioner
What if you look at?
has that the was driving the vehicle in a rash and negligent manner, and therefore there being evidence of rash and negligence, comma, a case, an offense is clearly made out under section 279 and 304 IPC A, 304A IPC. He further submits that the concurrent findings of the trial court as well as appellate court being based on evidence, comma, this court ought not disturb such findings. He further submits that there being no manifest or patent error on the face of the record, comma, this court, while exercising revisional jurisdiction, ought not interfere with the conviction rendered by the trial court, as well as the rendered by the trial court and affirmed by the appellate court. Stop. Correct? Anything you want to add?
On that much.
I have given my prudent consideration to the arguments made by the learned counsels appearing for both the parties, and I have perused the material available on record, including the decision cited at the bar. Stop. Up to reproduce relevant paragraphs of the judgment and order passed by the trial court. Quote unquote, paragraph 30, 31, 32, 33, okay? Page 22. Till paragraph 33. Huh? Then 32 is not required. 30, 31, and 33. I think 31, 30, 31, 33 is sufficient. Okay. Apparent reading of the aforesaid judgment and order of the trial court, that the trial court, upon by relying on the evidence of the apparent, it appears that PW1 the victim has deposed that while she was carrying her sister in her bicycle by pushing the bicycle, the truck in question driven by the accused petitioner driven in a rash and negligent manner, hit them from behind. She further deposed that her sister was thrown away and the rear wheel of the truck ran over the head of her sister, killing her instantly. She further deposed that the right leg was hit by the wheel of the truck, as a result of which her leg was fractured. She further deposed that she took treatment in the hospital for 1 month. It appears that the testimony of PW1 could not be shaken by the accused petitioner during cross-examination. It is evident from her evidence that the truck in question, having been driven in a negligent manner, hit them from behind, as a result of which her sister was thrown away from the bicycle and the wheel of the truck ran over her, killing her instantly. Ran over her head by killing her instantly. It further appears that PW2, who was PW2?
Independent business.
Businessman.
Independent business.
Who was proceeding towards his home at the time of the alleged accident, at the time of the incident, deposed that he saw the truck coming at a very high speed and while the PW1 was carrying another girl on the carrier of her bicycle and proceeding through the road, through the side of the road, the truck in question hit the bicycle and threw away the girls, as a result of which the leg of a girl was fractured and the wheel of the truck ran over the other girl by killing her instantly. He further deposed that after that the accused petitioner, by leaving the truck at the place of occurrence, fled away. Stop. It further appears that the accused petitioner could not shake that the aforesaid testimony of PW2 was also not shake and was also unable, could not shake, also stood unshaken whereas the testimony of PW2 corroborates the testimony of PW1 and proves the rash and negligent on the part of the accused petitioner. PW3, who was present in his shop situated near the place of occurrence, deposed that he saw the girls he saw the girls proceeding on the side of the road and being hit by the truck in question, for which one of the girl died on the spot, and the other girl sustained injuries on her leg. It further appears that during cross-examination, he clarified that the girls were proceeding on the left side of the road. He further deposed that he saw the accused petitioner driving the truck. Stop. Therefore, it appears that the aforesaid testimony of the PW3 also stood unshaken by the accused petitioner. PW4 similarly deposed that while he was proceeding towards Gorali, he saw the two girls proceeding on their side of the road, and the truck in question, by hitting them from behind, killed one of the girl on the spot. PW5 has not seen. PW6 is also not important. It further appears that PW7, who is the investigating officer of the case, has fully corroborated the prosecution case. Stop. He further deposed that the offending truck was found at the place of occurrence in an abandoned condition, and one girl was lying dead while another was lying injured. He further deposed that he prepared a site plan of the accident site, which he exhibited as Exhibit 4. It appears from the aforesaid evidence that the prosecution has been able to establish that the petitioner was driving the vehicle in question in a rash and negligent manner, for which the accident occurred, in which one of the girl died after her head came under the wheel of the vehicle in question. It further appears Who was the witness who said brake? One witness said about the brake. Which is the witness who said that he did not press the brake?
No, my lord, it is the finding of the court. Not
So there is
in
no skid mark. Is
page
there.
page
Okay,
33,
okay.
para 10.
It further appears that the exhibit 4, the site plan prepared by the investigating officer and proved by him during his deposition, indicates that the girls who were proceeding ahead of the truck in question on a bicycle on the left side of the road was hit by the truck from behind, and that the driver did not even apply the brakes or try to swerve the truck to the right side to avert the accident, as there was no skid mark. That part is in that particular
Page 33, it has been observed.
page.
33, my lord, paragraph 10, last, my lord,
You can fill the
4 line.
side plan also.
Rupak. Paragraph.
Page 33, my lord, paragraph 10, 7 line from bottom.
By applying brake or by blowing horn. That how will he know? Blowing horn. Brake, yes. By
Horn is-
applying brake. No, don't say that. Skid mark is given where?
That is not in evidence part.
Is it mentioned in the exhibit?
That- No skid mark is there.
Where? As there was no skid mark noted by the investigating officer in the site plan. Stop. It appears that the appellate court, after reappreciating the evidence, the aforesaid evidence, rendered its judgment and dismissed the appeal, assailing the judgment and order of the trial court. Relevant paragraphs of the appellate court is reproduced hereunder for ready reference. Para 10. Para 10. Okay. Relevant paragraph. Only para 10, page 33. This court, in exercise of revisional jurisdiction, cannot appreciate or cannot analyze, cannot appreciate or reappreciate the evidence. Stop. It is not the duty of the revisional court to look into the facts, and if two views are possible, and even if two views are possible, the judgment and order of the trial stroke appellate court cannot be interfered. It is only when the trial stroke appellate court has acted in ignorance of the law, comma, or there is no evidence whatsoever, or on the basis of no evidence, comma, the revisional court may struck down the judgment and order passed by the trial stroke appellate court. In the instant case, it appears that both the trial court as well as the appellate court, by fully appreciating the evidences on record, based on evidence, has held the petitioner guilty of the offense. Guilty of the offenses under section
279-337-30.
under section 279/304 capital A stroke 337 of IPC. Stop. The decision rendered, the decision of the coordinate bench of this court in the case of Kriti Singh Supra, relied by Mr. Sharma, learned counsel for the petitioner, comma, there is no proposition, there is no quarrel to the proposition that in order to constitute an offense under section 279/304A IPC, the proof of rashness or negligence is essential. However, stop. However, a decision is contextual and has to be applied to the facts and circumstances of each case. Paragraph 12 and 13 of the said judgment and order is reproduced hereunder for ready reference. Reading of the aforesaid judgment, it appears that the coordinate bench of this court has clearly held that criminality lies in not taking the precaution to prevent the happening of the consequences in the hope that they may not happen. Stop. In the present case, there is evidence indicate that in the present case, the appellate court as well as trial court, after appreciating the evidence, has held that the petitioner was driving at an excessive speed and has not pressed the brake so as to prevent the accident. Result for which the head of one of the girl came under the left wheel of the truck.
Yes.
Stop. That being so, I am of the unhesitant view that the appellate court as well as the trial court has unhesitant view that there is no legal infirmities in the judgment and order rendered by the appellate as well as the trial court. Hence, the revision petition fails. Dismissed. Huh? Sorry, Mr. Sharma.
My lord. Obligement.
Yes.
Rightly lost. My lord, this case, my lord, initially, lordship, the petitioner, three petitioners are brothers, lordship. They are convicted under section 325, lordship, for arrive for 5 years.
Item number 11.
Oh, lord.
There is an amicus curiae.
My lord, once I was not able to appear, lordship, and amicus curiae was, my lord, engaged, my lord,
But
subsequently.
since there is an amicus,
Which Chaudhary is there?
Yes.
yes.
By
Today
last
is not
order, I
there.
was allowed to argue, lordship.
It appears that that Mr. U. Chaudhary was appointed as an amicus curiae to represent the petitioners. However, today when the matter is called, the amicus curiae is not present. It further appears that you are the engaged counsel.
My lord, already I was engaged, lordship.
No, but I think we'll keep it on another date. If he doesn't come, we'll.
Yes, on the last date also, Lord and amicus curiae was. not
Tomorrow,
second.
lordship, we have fixed it on tomorrow.
Not tomorrow. You have read the file.
Yes, lordship.
Tomorrow.
Yes.
There's nothing in this revision petition.
I think there's nothing. Tomorrow.
Uh,
The day after or the next
Otherwise,
week,
after
lordship.
vacation, my lord.
no, no,
Leave vacation.
not after vacation. What is the case?
Case is lordship, three brothers were convicted under section 325, my lord. Initially 5 years, lordship, arrived for 5 years.
All right.
On appeal, lordship, it was reduced, lordship.
Kali ka ready দিও। পারিব না Tuesday?
Tuesday.
No, 2 তারিখ হই করে দিও।
Any date, lord, as per the convenience of the lord. Yes, lordship.
Let the matter be reposted on Tuesday, I so and so, by reflecting the name of Mr. U. Chaudhary, amicus curiae in the cause list.
এটা দিলে?
Tuesday.
The lordship, my lord, Wednesday maybe, my lord, I have
Okay.
some problem.
Wednesday.
Like that.
Yes, Mr. Bhatti?
My lord, there is court matter, my lord.
Huh?
This is an application section 482, my.
Yes, yes, quashing.
And quashing.
Section is
FIR.
420.
So 188 and 420, my lord.
Yes.
Very short, my lord, your lordship will find the FIR at page 20, my lord.
Page
20, 20.
20. Yes. Read, please.
Yes, ma'am. My lord, with reference to the subject and the government also referred to above, I am to request you to take action under appropriate provision of law.
Mr. Chaudhary, for which matter are you waiting?
Lordship, item number 13, in fact, Lordship, I have been engaged by the CBI just 2 days back and I was to make a prayer for some accommodation because I do not have the copies of
All
the
right.
position.
Other side?
Yes.
All right. Any objection? In item number 13, Mr. R.K. Chaudhary, you're for the respondent.
Yes, Lordship.
Learned counsel appearing for the respondent submits that he have been recently
Yes, Lordship.
he have been recently engaged in the matter to represent the respondent, and he requires some time to
Lordship will say prepared at least.
some time he needs some time to obtain the relevant papers and prepare the same and prepare for the same. Stop. Prayer is not opposed. List after the.
Also obliged, Lordship.
Yes, Mr. Bhatti.
May I read it, my lord? With reference to subject and the government also refer to above, I am to request you to take action under appropriate provision of law against the below mentioned Patadas who could be treated as offenders for violating the specific declaration made by them in the affidavits submitted by them at the time of obtaining NOC from Deputy Commissioner Kamru for purchase of agriculture class of land, and they would use this only for agricultural purpose. Now, my lord, I am not from Arun Gupta and Varun Gupta, but I am for Sanjay Gupta, my lord.
You are for?
Sanjay Kumar Kulsyan.
Achha.
This Sanjay Kumar Kulsyan, aged about 35, para 2, my.
Yes.
Pramod Kumar Kulsyan, residence of Das and such Kedar Road. The above mentioned Patadas has already constructed boundary walls factory in the agricultural plot of land, thereby thoroughly changing the nature of the use of land. Schedule of the land. This schedule has been given by me. Next copy of the affidavit is included. It is to be mentioned that mere fact that the land has been lying agriculturally unused for a long time or such.
Criminal case can be made out.
Yes.
No case has been made out under section 88 and 429.
Registered under 188, 420.
188.
422, there is no ingredient. 181.
One is
Because
that
the
relates to
allegation
this.
is not
disobedience of order.
Nature of the land.
Yeah.
That is the allegation?
Yes.
That he has changed the nature of the land by constructing boundary walls factory in the agricultural plot of land. That is the allegation. For this, there must be some civil consequences as well.
188 disobedience of order duly promulgated.
188,
And 420, my lord.
420.
420, there
is
are also
nothing.
no
There is no
engagement.
fraudulent
Yes.
inducement or a dishonest intention. That is
And
not-
88, my lord, there is
Huh?
no
Cheating
violation.
part is there,
What?
perhaps. Cheating part is there.
Cheating? What cheating? What cheating? Change the nature of the land. I'm not saying that there is no remedy. There could be civil remedies also.
Yes.
Disobedience to order duly promulgated by public servant.
It does not fall within the purview of section 188, my lord.
Therefore, knowing that by an order promulgated by public servant, empowered to promulgate such order, he then abstain from a certain act, with certain property in his possession under him. Because for criminal action, I'm sure mens rea is one of the essential ingredient.
Yes.
Obstruction, annoyance. And where is it saying that because he has done this, it is causing annoyance?
Nothing is there, my lord.
Where are these ingredients?
Extra
Nothing is that.
copy আছে
Extra copy.
Yes, how 188 has been attracted? Ms. Bora?
Lordship, I have to go through the file because I don't have any
So what's
petition.
the FIR?
Yes. Last, page 20. Page 20.
We have converted the agricultural land into.
That's what
some
I'm
other-
saying. Simply conversation, mere allegation of conversation is not sufficient. Mens rea,
Yes, Lordship.
criminality. Because 188, now read 188, read 188. Where
Yes,
are
Lordship.
these ingredients? Rupak. Fine.
Yes, Lordship. Disobedience in to order duly promulgated by public servant. Whoever knowing that by an order promulgated by a public servant lawfully empowered to promulgate such order, he is directed to abstain from a certain act or to take certain order with certain property in his possession or under his management, disobeys such direction, shall, if such
This
disobedience,
is condition precedent.
yes,
Now read.
shall, if such disobedience causes or tends to cause obstruction, annoyance, or injury or risk of obstruction, annoyance, or injury to any person lawfully employed, be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 2 or 100 rupees, or with both. And if such disobedience causes or tends to cause danger to human life, health, or safety, or causes or tends to cause a riot or affray, shall be punished with imprisonment of either description for a term which may extend to 6 months,
but fine, which may extend to 1,000 rupees or with both, lordship. So lordship, if anything causes harm to the public at large, lordship.
Where are those allegations? Where are those allegations?
No section implies,
Where are those allegations?
yes.
Nothing. In fact, it seems that this agricultural land was unused for a long time. See the last part of the FIR.
Lordship,
It is to be
it is to
mentioned.
be mentioned that the mere fact that the land has been lying agriculturally unused for a long time, but just excuses does not allow the landholder to use the purchased land for non-agricultural purposes until proposal for reclassification to appropriate classes is not recorded.
And how can the police so mechanically register offenses? It's absolute mechanical, no application of mind.
Lordship,
And who is this person who's lodged this FIR?
Lordship, circle officer,
Nothing is said. He himself admits that this is an unused land.
which has a
Then
long
how it
time.
can cause? All right, please take it down. Item 12, huh? Heard Mr. O.P. Bhatti, Learned Counsel for the petitioner. Stop. Also heard M.S.H. Bora, Learned APP for the state respondent. By way of this criminal petition under section 482 of the CRPC, the petitioner is seeking quashing of the FIR dated 23/9/2023, filed by the circle officer, Hajo Revenue Circle, which was registered as Hajo PS case number 366/2013, registered under sections 188, 420, 34 of IPC. Stop. The brief facts of the case is that on 23/9/2013, the circle officer Hajo Revenue Circle, Hajo, lodged an FIR alleging inter alia that the petitioner in respect of land measuring 1 bigha, 2 katha, 10 decha, covered by DAG number 289 of KP Patta number 278, changed the use of the land from agricultural to industrial purpose. Stop. Accordingly, the FIR was registered as Hajo Police Station case number 366/2013. Situated thus, the present quashing petition has been filed. Mr. O.P. Bhatti, Learned Counsel for the petitioner, submits that the allegations set out in the FIR, even if they are taken to be correct, does not constitute the offense, does not constitute any criminal offense whatsoever. He therefore submits that the registration of the aforesaid FIR under section so and so and so and so of IPC by the police official is totally without application of mind whatsoever. He accordingly submits that this is a that in the facts and circumstances of the case, the FIR warrants to be quashed by this court. Stop. For contra, MS SH Bora, APP submits that it is apparent reading of the averment set out in the FIR that it is alleged by the circle officer that the petitioner has changed the use of the subject land from agricultural purposes to non-agricultural purpose. And hence, the FIR in question ought not be quashed by this court. Stop. Heard, perused, considered. Apt to reproduce the FIR at the outset, quote unquote, page 20. A to A. On the basis of the averment set out in the reading of the aforesaid FIR, it appears that the allegation is that the petitioner has changed the use of the subject land from agricultural to industrial purposes. Stop. It appears that based on such allegation, the jurisdictional investigating officer registered the said FIR under sections 188, 420, 34 IPC. Stop. Apparent reading of the aforesaid initial FIR as reproduced here in above, no ingredients of dishonest, fraudulent or dishonest intention has been made in the FIR. That being so, no case of cheating on the face of such, no case of cheating is made out against the petitioner. Section 188 of IPC is reproduced hereunder for a reference, quote unquote 188. It appears that to constitute an offense under section 188, the disobedience is to be such that it causes or tends to cause obstruction, annoyance, or injury, or risk of obstruction, comma, annoyance or injury, comma, to any person lawfully employed, and also if such disobedience causes or tends to cause danger to human life, comma, health or safety, comma, or causes or tends to cause a riot or affray, comma, affray is essential. In the present case, except that the petitioner has changed the use of the subject length, there is no whisper as how the said disobedience has caused prejudice to anyone. Stop. Mere, except in the present case, there is nothing more. There is nothing more. Mere change of use of land is not sufficient to constitute an offense under section 188 of IPC. To constitute an offense under to constitute a criminal offense, to attract a criminal offense, comma, criminality must be set out in the FIR, in the averments made in the FIR. Stop. That being lacking, I am of the unhesitant view that the instant FIR cannot be allowed to proceed. Hence, the FIR dated so and so, FIR number so and so dated so and so is hereby quashed. Interim order was there?
Yes.
Interim order was there? Because then I'll make it absolute. I don't think it was there, Mr. Bhatti. Records have come, isn't it? According
12:30.
3,
12:30.
312.
3:12:30.
There's no 312, there's 412. 412, I don't have 312 here. Please pass it.
No, madam, no mistake.
Huh?
Records have been called for, and that's why no mistake.
Correct.
No mistake.
Accordingly, accordingly,
It was my problem.
let's post off.
My pleasure, Lordship. Lordship, this morning, my colleague here mentioned for an adjournment, Your Lordship. So I make a same prayer, Lordship. Matter will be adjourned for a day.
As prayed for by MS
L. Wangsa, Your Lordship.
L.
Wangsa, Your Lordship.
Alongside Learned Counsel for the
Petitioner, Lordship.
petitioner, relist after 2 weeks on a date to be fixed by the registry.
Bless you.
None appears for the petitioner on call. MSSH Bora present. List after list. Bihur pisar detail that detail. Yes. None appears for the petitioner on call. Relist after 2 weeks, 4 weeks on a date to be fixed by the registry. None appears. Mr. Singha, you're there?
Yes, sir.
Yes. You want some accommodation?
No, I'm for item 20, private respondent.
20 is gone. Yes. Where about 23? Where is finance? Probably this is not a regular bench and they may be.
No, they are aware of it. I've asked.
I'm sure they are aware. They must be somewhere else. Finance. Another date, Mr. Singha.
Your Lordship, can it be taken after some time?
Another date, heard
It's a
Mr. R.
part-heard matter,
Singha,
actually.
Learned Counsel for the petitioner. Stop. Also, none appears for the finance department on call. Relist, give it on next week or no 19. When do you want? Friday?
Can it be on third, Your Lordship, fourth?
Fourth.
Fourth will be
All right,
Friday.
now তার week hetu record episode on such an expect. This is 23.
Yes.
Your lordship, 9th will be, I think that will be the last working week before the puja vacation. It will be more.
Mr. Nayak, I was just posting it on another date.
Lordship. No, if it's, it can be taken up, your lordship.
All right,
Yes.
4th April. 4th April. Congratulations, Mr. Nayak. Nayak.
May I please your lordship? Lordship has gone through this matter, madam, the last occasion. I have come with four authorities, my lord. But this matter was looked by PP, Miss Vidhupavan Goswami. He is not present with the matter. This matter was looked by Mr. Midhupravan Goswami, but he is not present today.
Ms. Bora, Mr. Goswami is not there.
He may be next in other court.
Some other court, lordship.
All right, we'll have it on another date.
Lordship.
When?
Lordship, after Bihu vacation, lordship.
The Bihu.
Lordship on 10th,
10th
10th of April.
This is that case where the translated copies have been given. I think the last occasion, Mr. N. Mahajan had also argued.
Yes, in the last occasion.
Okay. But then, if I remember on the last occasion also, Mr. Goswami was not present.
Yes, madam. We have
Cannot
given him
go on like this.
Next.
This time we have come with the authorities, madam. It will be finished only, madam.
It's not that also he has to do. Anyone can do this.
Sorry. In fact, I remembered I fixed it today with the understanding that one of you will do. Look at the papers while I hear him.
Lordship.
Yes. Mr. Chakraborty and Mr. Nath, you all are waiting for which matter? The last matter.
Part heard matter, you will recollect, I Chaudhary had argued. And
This is not reflected as part heard in the cause list.
It is perhaps last time.
In fact, my lord,
And it was listed last Tuesday, my lord, when my lord had.
Okay, this is that matter.
That
but
matter of.
petitioner side has
This is item 27.
Yes, yes.
petitioner
Why
side
is
they
it
have
not reflected as cause list as part heard?
The
Because
lordship
it,
had heard that on
No,
20.
in that case, this would have been taken up earlier.
my lord, the written submission has been given by the petitioner. I have got the copy. I have gone through. My lord, I have also prepared one written submission. I can place it, my lord. I have placed reliance on two decisions. which I
That's
have
all right, but
mentioned.
when can we have it?
Actually, on the last occasion,
we are here.
that is on Tuesday, understanding was he will put his argument.
Correct.
Mr. Chaudhary will give a
Correct.
short.
So, therefore, I'm not going to close it right now, Mr.
Right.
Chakraborty. I am only fixing it on another date.
Okay.
Because this
Lot-
appeal will
lot-
take some time.
Lordship.
So I am just fixing it another date. Have it on Thursday.
No, I had talked with Mr. Chaudhary. He has suggested 8th of April.
All right.
8 is a Tuesday. Lordship.
Tuesday.
Lordship.
All right.
Lordship.
You give it on that day.
I'll give.
Or we
Lordship.
can give, we can come.
All right.
prepare-
All right.
We can come prepare and
yes,
then on that day, everything can.
Item number 27.
Yes.
Huh? Heard in part, relist on such and such date. You can give a copy here and also.
Yes, sir. But I'm giving copy.
All right. Yes. Item 26.
May I say also, lordship, to take up this matter on Wednesday, lordship?
No, why? Because I remember the last time when it had come, there was a specific mention by Ms. Bora that Mr. Goswami, APP is looking into it. And I made it very clear that either him or anyone else, how can this matters go on like this? This is a 2012. I had already heard once.
What should we heard once last week?
Yes. Again, it becomes difficult like this. Do you have the papers now?
Yes, sir. Just now I have got it, lordship.
Tomorrow then. You have any difficulty tomorrow?
Tomorrow, my lord, I am a senior, my lord, I have to go. My
Huh?
senior, my lord, I have to go with him, my lord, upstation.
Oh, you are going with your senior.
Yes, my lord.
When do you want?
Any day, Monday also, my lord.
Monday is a
Sorry, my
holiday.
lord, Tuesday, my lord.
Tuesday may also be a holiday. Thursday.
Well,
তেওঁলোকৰটো Thursday দিলো নেকি? নহয় নাই, তেওঁলোকৰটো 8 তাৰিখে দিয়া হয়। এইটো Thursday দিলো।
Lordship.
Huh?
Yes.
Sorry?
We will do this.
Yes, any one of you do it.
Thursday, Lordship.
And this is also, I think, part heard matter only. If you have already heard it. Heard in part, relist Thursday.
obliged to. Very obliged.
But Mr. Locker and Ms. Bora, please, you find out if he cannot do it, then one of you just.
Yes, Lordship will.
All is required is your assistance.
Yes.
Yes, Mr. Nut, anything?
Already.